As the court pleases. Muvangwa, initial N. I appear with Ms. Chaba on behalf of the first respondent, the president, instructed by the state.
Thank you, Ms.
Muvangwa.
May it please the court, I appear on behalf of the second respondent, Ms. Batohi. My name is Budlender, initial G, with my learned friend, Mr. Mbikiwa, instructed by Harris Nupin Mulabatsi.
May it please you, my lady, Nkabinde Inquiry for this top and fifth respondent on the instruction of the state attorney, together with my learned colleague, Mr. Mashalek. Thank you. Please.
My lady, I don't know if my learned colleague for the NPA on a watching brief needs to place herself on record.
Not necessary.
Not necessary. Okay. Okay. Thank you, my lady. I didn't want to be rude to my learned friend and start addressing you without clarifying that.
Thank you.
Thank you, my lady.
We should start with urgent.
Yes. May I give you a skeleton of what I intend to address, and then my first substantive topic after my introduction will be urgency. Thank you, my lady. So firstly, I'm just going to give you some introduction and context. Then I'm going to deal with urgency. Then I'm going to deal with and that relates to prayer 1 of the notice of motion. Then I'm going to deal with the president's powers in these circumstances, which is prayer 3 of the notice of motion. Then I'm going to deal with the pension payout, which is prayer 2 of the notice of motion. And then I'm going to deal with what I'm going to call the security or anti-dissipation relief, which is the last substantive prayer. Okay, well, I'm indebted. Should I give you the remainder of my skeleton then, or?
You might do the introductory.
Sure.
And then go to urgency, not first all the parties of urgency, make it really whether that is urgent or not, and then we go.
Okay. My lady, may I just place on the record that our client has hesitations around an independent assessment of urgency, and that urgency inherently requires an assessment of the merits.
I am sitting in this court, about always
Yes.
my urgent matters, because to listen to all accounts,
Yes.
if I do not find it's urgent,
Yes.
it's a waste of very precious
Yes.
initial time.
I'm willing to accept that. I'm just placing it on the record, my lady, that's the approach of my client.
And also accept that I've read all the papers.
Thank you, my lady. We're indebted, particularly considering the truncated timelines that your ladyship has done so, and given your ladyship had a full role, which I saw yesterday. So I'm indebted. My lady, can I just start then immediately with the introduction as a precursor to urgency, given what your ladyship has indicated? My lady, we live in this Alice in Wonderland world where, had the NDPP, former NDPP's term of office not come to an end, then it seems that all the respondents accept that there would be mechanisms available to inter alia the president under, for example, Section 12(6) of the NPA, to hold the former NDPP accountable for what might amount to misconduct. That's the world in which we live. And the world in which we also live is that all of the respondents, the participating opposing respondents, your ladyship knows the NPA was cited, they've fallen out for Part A. Your ladyship also knows the Treasury was cited, they've fallen out for Part A. But all the participating opposing respondents take this attitude that because the former NDPP's term of office has come to an end, accountability stops. The blunt force of the argument is that even if misconduct could be established, there is no procedural route or substantive power that enables anyone to hold a former NDPP accountable in the way the applicant asks for conduct that arose during her term of office. That's the Alice in Wonderland world we live in, where everybody simultaneously accepts there is an accountability oversight duty and mechanism, but at the same time say, oh, just because she's left office, we can't do anything about this. And therefore your relief, as you seek it against inter alia the president, is incompetent and untenable because 12(6) only applies to an incumbent NDPP. My lady, I would have imagined that's not controversial, because 12.6 obviously applies only to an incumbent NDPP. That's why the very relief that was prayed for in prayer 2 of the notice of motion explicitly talks about not a 12.6 inquiry per se directly in terms of the Act, but pertinently says, and I'm reading from 001-5, prayer 3, an inquiry in terms similar to that of 12.6 of the National Prosecuting Authority Act. So why it's important to introduce that, my lady, by way of introductory comment and to demonstrate that this is urgent is because, my lady, the applicant's case is that if nothing is done to prevent the pension payout and the other post-tenure entitlements that the former NDPP might be entitled to, if that is allowed to occur, that will constitute a rule of law harm.
Which post-term gratuities or payout? If I understand the papers correctly, and that is not, well, it cannot be disputed. It is clear that the second respondent will only receive pension payout to which she contributes.
Yes. Yes, that's right.
So it's only the pension we are talking about now.
I think, if I'm not mistaken, I think it was the second respondent who actually made that abundantly clear in the answering affidavit, that it's only the pension payout and there are no other post-tenure entitlements.
So we can leave that aside.
But for, may I just caveat that, but for obviously the debate about the funding of the legal costs, to the extent that there's a challenge that will come in Part B, that the legal costs that were granted in favor of the former NDPP ought to be reviewed and set aside contingent upon the same misconduct rule. And that is, if the former NDPP is found to have committed misconduct at the Nkabinde Inquiry, leave aside her disentitlement to the pension for one moment, she is not entitled to use state funds to litigate and, in inverted commas, protect herself from the consequences of that misconduct on the state dime. And that recently comes out from the Zuma versus Ramaphosa litigation about legal cost funding that happened exactly in this court, where the court said that you cannot rely on the state funds to protect yourself where it's demonstrable that the underlying conduct, which is the subject matter of the litigation, I don't want to say foreshadows, but rather advances a questionable lawful set of affairs that might have been unlawful, and your use of those funds to protect yourself from those consequences is incorrect. So I think we are in the same world, despite me originally saying we live in an Alice in Wonderland world. I think we're in the same Alice in Wonderland world where what we're talking about in today's proceedings, at least for Part A, is to, number one, ask the President to set up the equivalent inquiry. Number two, to prevent the payment to the extent that the payment is yet to happen. And number three, where the payment does happen, so assuming your ladyship is against me on the President and against me on urgency, that potentially there's still some relief that we may ask for, which is the so-called security and anti-dissipation relief. Now, I'm grateful for your ladyship for allowing me to make those comments by means of introduction, because what this case fundamentally turns upon, my lady, and let's leave aside Miss Batohi, Advocate Batohi's individual contribution to her own pension pot. What we're concerned with is the contribution of the state, qua employer in the broad sense, because obviously the NDPP is a constitutional office bearer under the Constitution and not a typical employee under the employment of the state, but the principles are the same with all due respect. And the point that we make is that that portion of the contribution to the pension that is made by the state for Miss Batohi, I apologize, I'm going to probably call her Miss Batohi, Advocate Batohi, the former NDPP, no disrespect. Or the second respondent. Or the second respondent, no disrespect is meant, my lady.
So do I understand it correctly that you only want to stop the payment that the government contributed? So she may get her own contribution, she must not get what the government contributed.
Yes, my lady, that would most sensibly be the case. I can understand in the papers that the case is perhaps presented a bit more broadly than that, and it's talking about the pension in aggregate rather than the different segmentation of the pension. But, my lady, with all due respect, the position of the applicant has always been a reasonable one. It's not to say that the second respondent is not entitled to anything ever. It's just that the second respondent is not entitled to anything that comes from the largesse of the state and which in turn may be predicated on misconduct yet to be determined. So the applicant's attack, so to speak, against the onward payout of the pension towards Ms. Batohi, the second respondent, is not that she must not get anything in the broadest sense. It's that she's not entitled to get anything where the getting of that thing, the monetary contribution, is predicated upon no further inquiry into the misconduct. That's really the nub of the part A of the case, my lady. So, with all due respect, because this is a rule of law issue, in the sense that we're talking about a potential rule of law harm here, does the state allow the pension to be paid out in circumstances where they ignore the misconduct challenge to Ms. Batohi?
Who pays out the pension?
The GEPF and the GPAA, the pension.
Not the president,
No.
not any of the other respondents.
Yes.
It is in terms of the funds, regulations.
Yes.
There's a board that must decide.
Yes, my lady. But that's why, and I don't want to, I heard some snickering from in the direction of my learned friends. I don't want to be pedantic about this, but can I just point out that if we go to the notice of motion again, is that, and this is a debate between the various respondents and ourselves, and this is not strictly related to urgency, so please understand I'm prefacing my remarks acknowledging all of that. If your ladyship goes to 001-4, first page, substantive page of the notice of motion.
It's just a moment.
Thank you, my lady. I am still coming to urgency. I have 6 subtopics to deal with, but your ladyship asked me a question, and I want to respond.
It's better that way,
In
that
the
we
nature of
progress
things.
and make sure what this matter is about.
Yes, my lady, of course.
Let's just see 001.
-4, please.
-4. Thank you.
At the bottom of that page, it's the first and or third to 11th respondents. Now, obviously at the launch of an application, particularly the launch of an application before a review record can be received, a litigant is caught between a rock and a hard place. Either you try to cite every conceivable interested party so that the non-cited party doesn't escape the efficacy of the relief, or at the same time you take a gamble, and gamble in inverted commas, and you cite all of them, and you make it clear that you only seek relief against them as appropriate. Now that's why, for example, my lady, prayer 2, which is about the pension payout, says as appropriate. Because what the attitude of the applicant is that I don't know the funny intricacies that go on between all of you as state representatives dealing with the potential pension payout. I might find that out when I have regard to the review record, but as I sit here, I don't know enough, and conceivably, on a reasonable basis, it looks like to me you state respondents, President, NPA, Minister, Treasury, all of the people who are closely associated to the NPA, including pay and rations, ought to be cited. So to the extent that the comeback is from our learned friends' clients, oh, well, it had nothing to do with me. Yes, we conceived that it might have nothing to do with
The
you.
board of the pension.
Yes, well, but you would see, my lady, 10 and 11 on that same page is the pension fund
Yes,
and
no,
the
I saw
administrator. And my lady, neither the pension fund nor the administrator have filed anything in these proceedings. No notice to oppose, no notice to abide, nothing of the kind. And they have been properly served with the papers.
Yes.
And I'm not asking your ladyship to draw any definite inferences against them for that. But what I would just simply and gently say to your ladyship is that if those are the 2 critical respondents, they were cited. If those are the 2 critical respondents, MK did its job by citing them, advising them of the relief, and citing all the other people it thought
You're
could be
quite
involved.
correct.
So, my lady, the GEPF and the GPAA take a supine attitude. They choose not even to say notice to abide or anything. And now all the other respondents, instead of arguing on the basis that the actual administrator is sitting on their hands, argues that this relief is incompetent because you cited me and you shouldn't have cited me. And my lady, just to round out this point, in the founding affidavit, after the citation of all the parties, that is expressly stated.
Yes.
We're citing you as appropriate. One last point on this, my lady, because it's a theme and a flavor that runs throughout all the respondents' opposition, and I might as well put it to the sword now whilst I've got your ladyship asking me the question. The point is this, is that look at what happens when Treasury responded to the letter of demand. Treasury says, nothing to do with me. What does the applicant do reasonably and responsibly? It says, okay, fine, don't come then. None of the other respondents reply to the letters of demand. There are 2 letters of demand. None of them respond to that. And they only start making their joinder, misjoinder, non-joinder case in the answering affidavit. Now, even if they are right that that's wrong, which it isn't because of what I've just told you, as state litigants, they all bear a higher duty and responsibility to litigate reasonably. Because the effect of them responding to us and saying, shaggy defense wasn't me, could have resulted in very many fewer respondents being cited for the purposes of Part A. So this attack on the competency on the relief based on this nebulous ground of non-joinder, misjoinder, with all due respect, over-eggs the pudding. Because the applicant can't be criticized for when a relevant respondent made its position known, releasing them as soon as possible. And so that's that whole joinder story dealt with. But to the extent we have to deal with the joinder, my lady, can I just point out?
It's just, I think we are going too wide now. Kindly return to the urgency of the matter.
May I just make 2 references, please? Your ladyship will look, when you're considering this joinder thing, at 001-5 prayer 3, you'll see why the joinder of necessity is there. And your ladyship will do the similar exercise, prayer 4, on that same page. So that's the joinder issue.
Thank you.
May I deal with urgency then, my lady? Can I give you the 6 topics under urgency that I have to deal with?
Yes, yes.
Thank you, my lady. Number 1, urgency is not self-created. Number 2, what weight your ladyship must attach to the letters of demand that weren't responded to. Number 3, what actually is substantial redress in due course. And the related number 4, that the existence of some other alternative remedy is insufficient for the purposes of substantial redress under the urgency test. Number 5, sorry, my lady, I'm just making a note, that in the context of urgency, litigation before the disbursement of the funds is appropriate, not after. And number 6, that the alternatives suggested are no alternatives at all. And my lady, number 7, to the extent I don't deal with it with you in argument, I'll have 1 or 2 things to say about truncated timelines.
Yes.
So my lady, strictly then on urgency. The first submission I must make to your ladyship is that the attitude taken by some of the respondents on urgency is that urgency is self-created for one of 2 reasons. And if I'm incorrect, my learned friends will obviously correct me when they're answering, and I'll deal with that and reply. But this is how I understand their case. On urgency, they say self-created for 2 reasons. The first one is they say, you always knew when the retirement period was coming to an end. And the second thing they say is you waited very long from the offensive conduct to launch the litigation.
That person whose cell phone just rang, kindly exit the court, switch off your cell phone and come back.
So you always knew the tenure when it was coming to an end, and then you waited very long from the offensive conduct. Can I address that first subtopic, this idea that because you knew that the tenure was coming to an end, you delayed inexorably, the consequence of which is that your urgency is self-created for this litigation. Now, my lady, 2 things to say in response to that. The first one is that obviously everyone knew when Ms. Batohi, the second respondent's tenure, was going to come to an end. But it's not the tenure coming to an end alone that gives trigger to the urgency. It's prior conduct before the tenure came to an end that triggers this application for urgency. So on this first more generic proposition that there's no, you always knew when the tenure was coming to an end, you should have acted sooner, that's obviously wrong, with all due respect, because it takes a fixed temporal time and attaches the litigation to the end of that temporal time.
There must be a trigger event.
Yes, that's the second response then to this whole question about you delayed and you waited very long. The answer to that is again twofold. Number one, no, we didn't, or rather MK didn't. In the first instance, it cites the trigger events that happened in the Nkabinde Inquiry, which, if I'm not mistaken, was either late December or into the early new year. That's when the offensive conduct started. And secondly, just think about what would have happened if we ran to the urgent court sooner on far shorter time periods against state respondents like the President, the NPA, the Minister of Justice. They would have all said, perhaps quite understandably, I've argued for state respondents before, this is too much time, these are very serious decisions, you're rushing us, this is completely unacceptable. So where an applicant is caught between a rock and a hard place, my lady, your ladyship will take a nuanced approach to the question of whether or not urgency is self-created. Yes, the trigger event happened when it happened, but your ladyship can't look, with all due respect, only on the dates of the trigger event and when the application was launched, and fail to engage with the chain of facts in between, where there were two substantive letters of demand sent to all of the respondents participating in these proceedings.
All of the respondents.
All of the respondents participating in these proceedings. I'll just take an instruction on that. It's being whispered to me that it was, but I'll confirm that and I'll come back to you. But
you'll need to direct my attention. But let's proceed. I do not want to.
Can I get the reference, and I'll do that when someone gives it to me?
100% you may proceed.
Thank you, my lady. I appreciate it. The first one, Ms. Matangwane is helping me, is MKP1, which starts at 001-85.
And that was demand, the letter to whom?
Yes, that was to the President. Sorry, my lady, we're just struggling with internet.
Case lines.
With internet collection, not so much case lines itself. My lady, can I do this? I'll come back to you and I'll give you those two. Either
I recall the letter to the President, the letter of demand.
Yes, I'm indebted to Mr. Mbikiwa. What I was trying to get to is where everybody was CC'd at the bottom of those letters of demand. And your ladyship will find that at 001-92 to 001-93.
001-92
and 001-93. That's the first letter of demand. There was a second letter of demand.
This letter of demand was addressed to all of the respondents.
It's may I read for you, yes, just to give you the parties? Sorry, my lady, there's just, if you'd give me a second. So if you look at 001-85, at the top of the page,
the President of the Republic of South Africa.
And then if you go right to the end of that letter, which starts at where under the signature line of my instructing attorney 001-92, you'll see the and to. And if you do the audit exercise, my lady, each one of those and to respondents are also the respondents cited in the litigation. So why I point that out is because if there's a criticism that you waited for 2 weeks or 6 weeks or 20 weeks or whatever between the trigger conduct and the launching of the litigation, these two letters of demand which go unresponded to are...
So the first one is addressed to the President, that is CC to the other parties.
Yes, my lady.
The second one is once again addressed to the President and once again CC to all the other parties. Seems like that. And let's just see, what is the third entry?
My lady, will you go to 001-90? Does your ladyship have it? About 2/3 of the way down the page, additional demands of state parties. in addition to what is set out below, we specifically call upon the listed entities listed hereunder to confirm that they shall not do anything. So yes, the letter is ostensibly directed towards the President and the office of the President, but all the other conceivable entities, because remember, when the letter of demand is being written, as I said to you earlier, my client MK can't be criticized for knowing the nitty-gritty which occurs in the bureaucracy of the state. It's taking reasonable steps to cite every possible litigant who might form part of the...
Mr. Badlander, I can hear you.
I apologize, my lady.
Thank you, my lady. So that's what's there. And the similar situation, with all due respect, my lady, is that the second letter of demand is also sent.
Yes, I saw that this is the letter sent on the 12th of January, 2026.
Yes, I think that's the first one that you and I were just talking about.
Now, what is
Oh no, that's 30 January, I apologize.
it says letter?
Yes, that's MKP 2, my lady. That starts at 001-98.
So the letters should
They're the-
actually
they're-
be the other way around.
They're the other way around, I apologize for that.
Not a problem. So the first letter was sent on the 12th of January,
Second letter.
on the 30th.
Yes, my lady.
Thank you.
And can I just say, for the sake of the record, that story about citing all the relevant parties, you'll find at 001-102 and 001-103. That's the January 12th letter.
Yes, yes.
So, my lady, your ladyship will apply herself to this question of self-created urgency in the context of whether or not you just sat on your hands supinely or you took steps to try and resolve the matter without having to go to court.
Yes.
Very importantly, my lady, I would also say a weighty consideration, and now I'm moving on to topic number 2, is that your ladyship will
Just
know
remind me, topic number 2.
the weight you are going to hopefully attach to the letters of demand, which we've just discussed under topic number 1, urgency is not self-created,
Wait to be attached to the letters
to
of
the
demand.
letters of demand.
Yes, you may proceed.
Because, with all due respect, my lady, the respondents take a hard attitude towards MK. Understandably so. I suppose any respondent in an urgent application would do that. And that's to say, your citation of me is wrong, it's improper, there's a misjoinder, I'm incurring costs where I shouldn't have to do so, I have no powers, all of those stories. Now, I'm not going to repeat what I've just said under urgency is not self-created and the letters of demand weren't responded to. Instead, what I'm going to simply say to your ladyship is your ladyship knows the authority from the likes of Transnet versus Rubinstein in the Supreme Court of Appeal, which is that where a party seeks to avoid litigation, which may have the consequence of factual and or legal delay, a court will bear that in mind
Yes.
when considering if urgency is self-created or not.
It is actually to be applauded that rather try and sort this out before you come to court.
Well, I would imagine so, my lady. But I'm not gonna resist the temptation to snatch at that bargain and say absolutely it's to be applauded. MK acted reasonably in the circumstances. But your ladyship has the point. So when you have regard to those letters of demand, my lady, you will bear in mind that even though that has the consequence of elongating the timetable perhaps between the trigger conduct and the launch date, that those two important intervening factors nuance this idea that there was self-created urgency.
Undue delay.
And undue delay, of course, my lady. May I go to topics number 3 and 4?
Yes.
If your ladyship is okay, I'll deal with them together.
Yes.
It's this idea about substantial redress and whether or not an alternative remedy is sufficient for substantial redress under the urgency test. Now,
Substantial redress and alternative remedy.
yes. And what I'm going to give you as my head note, my lady, with all due respect, is that those are distinct concepts. Alternative remedy is the interdict concept. No substantial redress in due course is the urgency test concept. And what I'm going to say, I'll take it one step further, is even if a cognizable alternative remedy exists, that is not sufficient for the purpose of substantial redress in due course. And the reason for that comes from a case which I've given my learned friends notice we would rely on. And I think it has been uploaded. It's called an additional list of supplementary authorities.
You can just give me the case now.
Thank you, my lady. I'm told, my lady, that the list which was emailed is in the process of being uploaded on case lines, but the citation of the case is ZA Online Store.
Yeah.
Trading as iStore versus Derrick and others. It's an unreported case, 2025, from the Johannesburg High Court, dated 9 June.
Oh, it should be on SAFLI.
So it is on SAFLI. I'm giving you the SAFLI
so
citation.
It's 2025, then it should be ZA.
So it's square bracket 2025. Then I'll give you the ZA citation. ZA GP JHC, so Johannesburg High Court, 734 round bracket 9 June 2025.
Thank you.
I'm using the SAFLI citation as well, my lady. But, and my lady, may I just preface what I'm about to say with understanding that, of course, urgency is a highly discretionary decision made by an individual judge, and just because one judge determined one thing a one way doesn't mean another judge is bound to do so.
Always.
Exactly, exactly. But what I'm instead gently trying to make a submission on, my lady, is this, is that when your ladyship obviously applies her mind to the question of urgency in the way your ladyship said you would, the substantial redress question and the attitude of another court is something that your ladyship ought to consider in the round of applying her own separate discretion to this particular issue. What her ladyship, this was a judgment, if I'm not mistaken, of your sister Dippenaar. I apologize, that's a different judgment. It's Judge Duplessis in Johannesburg, a newly appointed Judge Duplessis, if I'm not mistaken, in Johannesburg. And she says the following at paragraph 37 of that judgment. I'm going to read, my lady, if I may.
Yes, thank you.
The notion of substantial redress as a hearing in due course, as contemplated in Rule 612B, requires that the remedy be not merely available, but also effective and meaningful in the circumstances of the case. The question of harm is not the pivotal question, but an absence of substantial redress in due course. And then her ladyship Justice Duplessis quotes the famous East Rock trading at paragraph 6 and 7. So the point, my lady...
That is the Tuchting judgment.
East Rock.
Yes.
East Rock is Nochi AJ. Nochi AJ. I speak subject to correction, but I'm almost certain it's Nochi AJ. When I've been in the urgent court for and against, I've used that judgment on more than one occasion. So I'm gonna peg my colours to the mast. But my lady, what her ladyship Justice Duplessis says at paragraph 37, it's not any alternative remedy. It needs to be judged in the circumstances of what the relief is being sought. So what are the three arguments?
Well, the substantial redress, because the alternative remedy, as you've indicated, is one would consider that in the
interdict portion.
Interdict.
Yes.
So at urgency, the question is substantial redress.
Yes, and the point that I'm making, my lady, is when you examine what our learned friends' clients advance are the alternative remedies, and you analyze those alternative remedies as against the relief sought in the notice of motion, you'll find that they're totally disjointed to each other. Because the attitude taken by our learned friends is that you've got an alternative remedy that kicks you out both for the interdict and urgency. But what we are saying is in line with what Justice Duplessis says. The inquiry is slightly more nuanced than that. And so what are those three alternatives remedies that they talk about? They talk about go and complain to the LPC. They talk about go and lay a criminal charge at the SAPS. And they say go exercise your restitutionary rights or your recovery actions against Ms. Batohi, the second respondent, for what you contend is an unlawful payment to her.
As far as I'm aware, and maybe the other parties maybe could address me on that. I'm just thinking as a general rule, pension payouts, as far as I'm aware, there are monthly payments and there might be well, that is if one reads the law, you will be able to determine it.
Yes, yes.
So we do not know how much is going to be paid as a lump sum and
No.
how much is going to be paid monthly.
No.
So, for instance, if the second respondent, maybe let's not discuss it at urgent stage.
Because that takes us into the merits, perhaps.
Yes. No. Yes, you may proceed.
Thank you, my lady. So I was just sticking with those three alternatives
Yes.
they put up. And my lady, if you do the simple audit exercise of looking at each one of those alternatives they put up as against the relief in the notice of motion, that's obviously insufficient for substantial redress in due course. Because what your ladyship knows, if we go back to the notice of motion, your ladyship had it earlier, at 001-4 and 001-5, is that on the second prayer, which is to prevent the actual pension payout, the LPC is not going to give me effective relief, the SAPS is not going to give me effective relief, and more importantly, when my client MK acts in respect of what it calls state money, it's not acting as the state. It's acting as a public interest litigant, asking the state to do its job to prevent that final disbursement. So the consequence of that, my lady...
Well, the state's portion of that.
Yes, I accept that. But my lady, why I'm tying that back to the prayer in the notice of motion is that it's insufficient for the respondents to say, well, go away and just...
No, you've made that.
Thank you, my lady. And my lady, we would say that that, with all due respect, applies with equal force in respect of prayers 3 and prayers 4 of the notice of motion. So there's no substantial redress in due course if your ladyship is against me on urgency, or if your ladyship is with me on urgency but dismisses me on the merits, because none of the relief that they say are the alternatives are true alternatives for the purpose of the urgency inquiry you are dealing with at the moment. I'll obviously deal with those under alternative remedies under the heading of sufficiency, but I don't have to go there now because your ladyship accepts the distinction that I'm drawing having regard to what Justice Duplessis said in that judgment that I cited. So, my lady, that's the substantial redress and the alternative remedies and the distinction. That's topics 3 and 4, if I may. Topic number 5. This is another authority I advised my learned friends we would have regard to. It's a matter called MEC, Free State Department of Health versus Polori and others. It's also a SAFLI citation, my lady. Square brackets 2025 ZA FSHC 343, and it's a judgment dated 31 October 2025. It's a judgment of His Lordship Justice Daffy in the Free State High Court. And my lady, I just want to, because remember, this is in the context of urgencies, and we're talking about harm and substantial redress and all these kinds of things.
Yes.
I just want to point out what Justice Daffy said in the context of another pension disbursement case, and I want to compare and contrast that with the situation that we are in. May I read, my lady? I'm going to read from mostly paragraphs 11 and 26 of that judgment, if I may.
Thank you.
Thank you, my lady. In paragraph 11, about...
So this is also pertaining to the, is it the 11th and 12th respondents?
Yes, well, it would, because remember the 11th and 12th, the GPF and the GPAA are the hand that executes.
Yes.
So that's really, it would be
Who
as...
was the respondents in that matter? Who were the respondents?
It's two pension fund payout claimants, my lady. Polori, and then the other one is Stuurman.
Yes, you may proceed.
Thank you, my lady. I'm reading from about 4 lines down in paragraph 11, so I don't want anyone to think I've conveniently left that out, but I'm reading from the critical portion. It says the following. The Supreme Court of Appeal has authoritatively stated in another case, Highveld Steel and Vandium Corporation Limited versus Oosthuizen, which the judge refers to as Highveld Steel, that the wording of section 37D1, 37 capital D, bracket 1, bracket B, would render an employer's protection meaningless. Therefore, to give effect to the intention of the legislature, the wording must be interpreted purposively to include the power of the pension fund to withhold payment of a member's pension benefits pending determination or acknowledgement of the member's liability. Consequently, the court held that the fund in that case had a discretion to withhold payment of the respondent's pension benefit in the circumstances, and that such discretion was properly exercised.
Let's just ask this. Was there already a decision by the fund to withhold?
Yes, my lady. And what happened in that case is there the court prevented the payout.
No, I understand that. Because one cannot speculate
Yes.
what the fund is going to do.
Yes.
So once there's a decision and the payout will follow, then at least one knows what type of relief should be claimed.
Yes, that's exactly. Can I finish reading out that
Because
paragraph?
if the board decide not to pay out and to withhold, then
Pending
this,
the
no,
determination.
this application, well, I'm still on urgency.
Yes, yeah.
Yes.
No, but my lady, may I say that if the fund came to the party, so to speak, and said, we will withhold pending whatever outcome or determination about the lawfulness of the claim to the pension is resolved, then obviously my application couldn't be urgent in the circumstances to get that interdict relief, because the fund and the administrator would have effectively given me the restraint relief that I otherwise seek.
Yes.
So, and just to tie that back to what I said earlier, the absence of the fund and the administrator participating in these circumstances where the subject matter is about a potential payment to be made by it, and it knows that there are allegations and relief aimed at it to prevent that payout, and it chooses to stay stum in the circumstances, can't be flipped over to demonstrate some or other unreasonableness on the part of my client when my client comes to court and says, I don't know what's happening, but here are all the people I think are implicated, and here's how I understand them
Yes, but
to be
there
involved.
must be at least some urgency.
Yes. No, no.
I agree with you.
Yeah.
And what the applicant does, the applicant may always do. That is what courts are for.
Yeah.
But we are now in the urgent court.
Yes, indeed. Can I finish reading that paragraph?
Yes, please.
Thank you. Consequently, the court held that in that case, I think I've read that already, the discretion was properly exercised in view of the glaring absence of any serious challenge to the appellant's detailed allegations of dishonesty against the respondent. And it went on to say, in that particular case, and this also talks about why no substantial redress in due course the dissipation relief, I'm reading from paragraph 26 of that judgment, about 3 lines down. The test for irreparable harm is an objective one.
But that is once again interdict.
Yes, but may I just read this paragraph
You may.
to demonstrate the connection to what we're asking for, why it's urgent?
Yes.
With your indulgence, please, my lady. Thank you. Mr. Polori is unemployed, that he is presently involved in a criminal trial in the High Court where he is one of several criminal accused relating to damages caused to the applicant due to alleged criminal acts committed by the accused persons. He submitted during oral...
Is it your client sitting at the back?
I have absolutely no idea. Yes, well,
It's
at least the
absolutely
clients that I can identify wearing T-shirts.
Disrespectful to the court. I'm going to adjourn for 5 minutes. Kindly inform your clients what the decorum in court is. It is the second time. Court will adjourn for 5 minutes. Thank you, Mr. Bennett. You may address.
Thank you, my lady. Firstly, we apologize for that disturbance a second time. Secondly, my instructing attorney has advised those persons associated with our client as to the decorum of the court.
Thank you.
Third, they also apologize and are sorry that it happened.
apology accepted.
Thank you, my lady. I'm indebted. So, my lady, from those two cases, those two quotes from that paragraph that I apologize, let me start again. From those two paragraphs that I read out to you regarding that pension dispute,
Yes.
there are two things that I would say arise from that. The first one, my lady, is where there is a question about the lawfulness of the entitlement to the pension, which in turn implicates, did you commit misconduct? Are you claiming based on fraud or any of those kinds of things? And I'm only dealing with this in the context of urgency. Then, my lady, that is a sufficient trigger for an applicant to approach a court to say that you can't allow this pension payout to happen without the determination of the enabling entitlement, because if you don't determine the enabling entitlement, the consequence potentially is that you've let the money go, and down the line you may never be able to effectively recover that money because it's already been dissipated.
Yes.
And how that relates then obviously to the urgency, my lady, is that relates to the prayer as against the president, which is rather than wait and let the money be dispersed and then maybe determine your recovery action after the fact, do it now whilst you still have the time and the opportunity to do so. And to the extent that then the second part that I read out to you in the context of urgency, that creates the basis to say for the security or the anti-dissipation relief, if we're wrong on everything else and you ultimately get out your payment, give me some level of security so that I know when we come after you in due course perhaps, that you've made provision to say that the money is protected so that if there is a recovery action, there's something to recover from. Because otherwise that invites a position in the that invites a person in the position of the second respondent to say, well, come after me in due course, I'm not going to do anything, and then magically all the money is gone, and how do you recover effectively? And, you know, this litigation...
I think there are some instances of other matters, and maybe that's not relevant because we're dealing with urgency, but the difficulty in recovering.
My lady...
I think there's someone from ESCOM, but that's not relevant.
My lady... As that relates to urgency, we would say that's the grounds for urgency. Rather do it now and freeze the status quo before any irrevocable change happens. And even if that change is not irrevocable, it might be incredibly difficult to recover. That's what all those authorities tell you in forfeiture matters or in anti-dissipation orders or anything of that kind, is where you can identify the protectable interest in advance, do what you can to protect that interest so that what may happen down the line isn't rendered moot or academic or impractical because you didn't do it at the time where you tried to do it when you did, which is what MK says to you is what we're attempting to do. So in the context then of doing it before the disbursement under urgency, rather than after the disbursement, that's the argument to you, my lady, on the issue of why we're here now and why your ladyship should consider the matter urgent. Lastly, my lady, I said I was going to deal with the topic of those alternatives. I don't have to deal with that. I think we've dealt with that already. My lady understands the distinction between substantial redress and alternative remedies, so that is what it is. I don't have to deal with that anymore. And then, my lady, to the extent that there's any complaint about the truncation of timelines, the only thing that I would say is that the truncation of timelines is in the nature of urgent proceedings. The question is whether or not it was reasonable in the circumstances. We submit it was reasonable in the circumstances, especially having regard to the non-responses to the two earlier letters of demand. To the extent the respondents nonetheless suggest that they are prejudiced by the truncation of the timeline, I'd only point out that they fully have dealt with the case made against them, even to such an extent that other respondents have been cut out on the basis of what they say about Part A. So any prejudice in the round must be weighed against the prejudice of not entertaining the matter as an urgent one. My lady, I've kept you for about 50 or so minutes, which I'm indebted for. May I take an instruction? And then those are my submissions on urgency. My lady, those are my submissions. I'm indebted.
Thank you, Mr. Freeman. Yes, for the first respondent, it's Ms. Mavungwao.
Muvangwa, it's easy on the tongue. Muvangwa.
Okay, Muvangwa.
Yes. I'm indebted to your ladyship for trying. My lady, I've listened to my learned friend very carefully. I wonder whether it might be of assistance to map out the order of my submissions so that your ladyship would anticipate responses to what was argued, so that we don't jump around. So on the subject of urgency, my address is structured in 3 ways. I start first with the principles that govern urgency, because I think that's important. The second thing I will then do is to argue that there is substantial redress in due course, and I will refer to cases where that was in fact held to be the case. The third argument I would advance to the court is that to the extent that there is any urgency at all, that is self-created, and considerations of prejudice ought to be taken into account by the Honorable Court. The first proposition we would like to advance, my lady, is that the application simply does not meet the requirements for urgency as set out in Rule 12 and as expanded.
Rule 612.
Rule 612, correct? Thank you. I'm so married to this Section 12 story. Rule 612 of the Uniform Rules of Court, but that's also expanded upon by case law.
Yes.
So I promise to commence with the legal principles, and I will. My lady, the test for urgency is not that the matter is important.
I totally agree. It is an urgent
It is
court,
whether the applicant will be denied substantial relief later. That, my lady, is a factual inquiry, and it has nothing to do with the applicant's own sense of importance. Now, why do I say that? When regard is had to a decision that was referred to in my learned friend's heads as well as the principle was teased out, is the Mogalakwena local municipality case that your ladyship will find at, I think it's at different places in the bundles. I have here a 007300.
Just a moment.
But it's also at 00600. Either one of those will get you there.
Which one would you want to refer me to?
Whichever is
00?
quicker for your ladyship.
I beg your pardon?
Whichever is quicker to get to for your ladyship. So it's either 006 at 600.
I do have that.
All right. So if your ladyship would please have regard to paragraph 64, and that if your ladyship is in the 600 series, in the 006 series,
Yes, this is the Tuchten judgment that I thought.
Yes.
Because it's well in this division. It's
That's correct.
very well known decision.
That's absolutely correct.
Yes.
Now, if your ladyship would indulge me, I will read paragraph 64. But from my notes, because I have enlarged a little bit, the paragraph reads as follows. It seems to me that when urgency is an issue, underline please the following. The primary investigation should be to determine whether the applicant will be afforded substantial redress at a hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. Once such prejudice is established, other factors come into consideration. I will pause there. My lady, we submit that the prejudice element is the threshold, and where substantial redress is available later, urgency cannot be established and the inquiry need not proceed any further. We argue that there is indeed substantial redress later. There is relief later, not today, later. We do this for 3 reasons, and I will take your ladyship through them in sequence. The first reason, my lady, is what we call the corruption watch principle. The judgment corruption watch is in the 007 series at page 40.
Thank you.
That was a constitutional court decision and it directly addressed the question of recoverability of benefits that were paid to a former NDPP, the irony of it. And in that case, the court confirmed that funds that were paid to a former NDPP pursuant to an invalid settlement agreement were recoverable by way of a restitution order, an ordered repayment of over 10 million rand. That order, Your Ladyship, will find, in fact, in paragraph 14 of the judgment, in the order itself. 10 million rand was ordered, paid back, you are not entitled to it. That is substantial redress that was afforded later. The court held that a repayment was the natural legal consequence of a declaration, in that case, of constitutional invalidity. Wherein lies the analogy? My learned friend's case is premised on this idea that the law is being broken universally. If it is so that the law is being broken by my learned friend's client, there is redress later. If it is in fact found that she broke the law, she would be ordered to pay back the money if she was not entitled to it. So that's the first reason.
Who's this?
I beg your pardon, my ladyship?
Now I'm thinking. You may proceed.
Is your ladyship asking me who the NDPP was?
No, I'm just thinking, this process, there are allegations
Yes.
that needs to be
Tested.
verified.
That's correct.
And then a decision will, so there are so many decisions
Correct.
that still needs to be.
Correct. And I don't intend to speak on behalf of the second
No,
respondent because my learned friend, Mr. Butlander, is in court. But it will be recalled on the facts of this case that the whole case is built around this idea that she behaved badly at the Nkabinde Inquiry. The Nkabinde Inquiry is ongoing, and it is on affidavit that she asked to consult a legal representative, and she has now filed an application, I believe on the 26th of February, my learned friend will correct, where she wants to consult with her lawyers, because that's important, because she's under cross-examination. But I digress. The point is that once those allegations are tested, once the Justice in
So
Cabinet...
the Corruption Watch matter, was there already a finding that the payment was
Yes.
unlawful?
Yes, there was. Well, the court made that finding, and as a consequence, and that's why the court says
Yes, no.
the repayment is a natural consequence of the finding of constitutional illegitimacy. So we argue, my lady, that the principle, the Corruption Watch principle, is on all fours applicable here. And the court, we ask, should always not lose sight of the fact that the Justice in Nkabinde inquiry is still ongoing. And it's a lot of this, what has been brushed as bad behavior, from where we stand today, seems to me to have been smoothed over. But my learned friend, Mr. Butlander, would speak to that, not me. But what is important, though, is it's very interesting that the applicant has not explained to this court at all why the Corruption Watch principle would not govern a situation like this. And we note quite a loud silence in dealing with that case altogether. My lady, so that's the first reason. It's the Corruption Watch principle. I promised you 3 reasons on the score. The second reason is what we call the restitution intellectual remedies.
Yes.
Now, Corruption Watch aside, your ladyship will be familiar with 2 aspects of South African law. It's the law of unjustified enrichment and the law of delict.
Yes.
These provide as additional mechanisms for the recovery of monies that were unduly paid.
Well, there is also the principle that the anticipation order, anti-dissipation order,
Yes,
that's also a legal principle that a party may, I have this matter that still needs to be dealt with,
yes.
and pending the finalization of that matter, I want to freeze or I want to keep safe. That is also a principle.
That's correct, except the difference here is your ladyship is given no facts whatsoever. Or the idea that the second respondent might dissipate is a conclusion. Your ladyship has been given no facts whatsoever that would lead to such a reasonable conclusion. Nothing. All we know is that she retired. She used to contribute, by the way, to a pension. And my learned friend from the minister will unpack all of that. We are told she retired, and on retirement, you get paid this pension fund. But you might blow it. You might go to Los Angeles, you might go to Las Vegas. We don't know. We've been given no facts whatsoever. So the submission is, yes, anti-dissipation is a legal principle, but it cannot be pie in the sky. All right.
Of course, that is also relevant to urgency. If there's no facts
Yes,
to support the anti-dissipation,
yes,
then the matter can never be urgent.
yes. You have been given no facts. My learned friend will tell me where the facts are in the founding affidavit in case I missed them. So, and I must give you some case authority. The principles of unjustified enrichment and what is available under the law of delict have been held to be available and recognized in the context of executive decisions. In fact, by this division, 2 cases, or maybe 1, I mustn't be so enthusiastic. It is the Presidency of the Republic of South Africa and others versus Zuma and others. It's a 2025 decision. The case is in case lines 007 340. I just
007
007 340.
340. Yes.
So, my lady, the availability of these remedies demonstrates that any harm arising from payment is not irreparable and is legally cognizable in the sense that you can retrieve it. So that's the second reason. 3 of 3. The third reason, my lady, is what we call available mechanisms of redress. I step back. As against my client is told, and it was repeated now, although it is hinged on this idea that the second respondent might dissipate, my client is told to come here quick, fast, not, it turns out, to answer to all the plethora of the relief that was sought against him, but only to urgently establish this unlawful Section 12. So we get to that in a moment. Section 12(6) story here. Okay? We are not told, what my learned friend was talking about is this, and the money might disappear, it might evaporate. There has been no submission made whatsoever why there is not substantial redress available to the applicant in due course as far as it concerns the president.
Yes.
Why do I argue this way? It is common cause that the second respondent is an advocate. She's an officer of this court.
Yes.
As such, the Legal Practice Council has authority over her, legally, professionally. The Legal Practice Act makes provision for the council to discipline and hold to account its members.
And that is the specific act.
Yes.
That's applicable to any wrongdoing of
An officer of this court. And that applies on all fours to the second applicant. I have not heard a single submission why that is not available as far as the relief is sought against my client. Why must my client come here on an urgent basis in circumstances where the Legal Practice Council jurisdiction is available? There is more. To the extent that there is suspicions or allegations of criminality, it is available to the applicant to approach the police service. We have heard no submission, I have not seen any, why those remedies are not available.
No, I think the problem with those remedies, if I understood the submissions correctly, is that will not save the payout. That will not stop the payout.
Yes, but you see, Malay,
But I hear you. You are now...
I'm for the president. It has been clarified
Yes.
that, as a matter of fact, the only relief that is sought against the president, it's that he sets up this, establishes this inquiry.
Which you cannot do in terms of the act.
So we argue, but by the way, my learned friend said we are I can never say that word. I don't even know why I brought it up. Obfuscate. That one. Thank you. Matters. It is correct that in Part A of the notice of motion, his client refers to an inquiry similar to that contemplated in 12.6. Part B says an inquiry in terms of Section 12.6.
But, yes.
But this, in any event,
But, yes, no, we're not going to go there now, but there must be some other legal
yes,
basis
we will. I
for
want
any
to.
form of inquiry.
That's quite correct.
It's
But
either an act or it is, there are various manners in which an inquiry can be instituted. Isn't
Yes.
that so? Now, yes, you may proceed.
all right. So, my lady, each of these mechanisms that I have now engaged the court on,
So far as the first respondent is concerned.
as far as my client is concerned, I'm just here for one man.
One man only.
One man only, that is correct. As far as my client is concerned, there are three, so the inquiry can stop now. There is substantial relief available later.
Yes.
And I have told the court what these are. Okay. But out of an abundance of caution, I will go on to deal with the second topic, which is,
Counsel, will this
Oh,
be a
that is-
convenient time?
that would be a convenient time. I apologize, my lady.
Not a problem. The court will adjourn until 11:30. Toegten.
Yeah, no, I have to breathe. It's a weird thing. Justice Tuchten's passage from that Mocha Lakwena local municipality. I want to commence the second half of my address by reading the second half of the paragraph, if your ladyship will indulge me, please. So, Justice Tuchten then says, after he says, if there is substantial relief later, that's the end of your inquiry, all right? But then I said to your ladyship before we adjourned that out of an abundance of caution, I want to address the remainder of it. And here we go. Going again back to principle. So the learned justice says, if the applicant cannot establish prejudice in the sense of substantial relief later, the application cannot be urgent. That's the end of the inquiry. But then he continues. Once such prejudice is established, if they come over the first hurdle, then other considerations come into play. There are these. They include, but it's not a close list, whether the respondents can adequately present their cases in the time available between the notice and them having to come to the hearing. That's one. Two, other prejudice to the respondents and the administration of justice. That's two. Three, the strength of the case made by the applicant and any delay by the applicant in asserting its rights. This last factor is often called, usually by counsel acting for the respondents, a self-creating urgency. So the last bit is the last one is the delay. The self-created urgency is the delay. I wanted to go back to the principle for two reasons. One is to say I wanted to canvass my submissions on principle, but also because I've noticed, your ladyship, we are not disallowed from venturing into the merits. I say this, merits are not irrelevant, and that's what the justice says there, the strength of the applicant's case. So boldly, if I may, the applicant's case as vis-a-vis my client is poor. My client simply has no power. And that I say, I make the submissions in the context of urgency, yes, because it is relevant. And I noticed that your ladyship kept wanting to go there but kept coming back. It definitely is relevant. Okay, so my next topic to deal with then is this. The topic is called, to the extent that there is any urgency, which we deny, that urgency is of the applicant's own making. We say this for three reasons, three considerations that demonstrate this conclusively. I will get to the letters, promise. The first one is what we call the prior knowledge factor. My learned friend for the applicant says, doesn't avail, doesn't matter.
When it came to the end.
When it came to the end, it does, and I'll say why. The applicant has members that have knowledge of the public service. So therefore they were aware, or ought to have been aware, long before the December line, that Advocate Batohi would be retiring upon attaining the age of 65. At the very least, on a factual level, and this your ladyship would find in my learned friend for the second respondent's answering affidavit, it's not in my client's, that as in October last year, an advertisement was placed publicly to solicit on a panel to solicit nominations. That was very public. So that is the first time that that information would have come reasonably to the applicant's knowledge. And it is also ought to have known, in any event, ignorance of the law is no excuse, that in terms of the NPA Act, read with the Public Service Act, once somebody retires, they're done. There's no more administrative act required. The NPA Act says 65, you read that together with the PSA, you're done. It's ex lege. The applicant, as I said, includes within its ranks former public office bearers and members of parliament who, on any fair assessment, my ladyship, we have got to be reasonable and fair on assessing this. on any fair assessment ought to be familiar with the applicable statutory timelines governing the NDPP, their tenure and post-tenure benefits. I must say on that score that it was very interesting to hear my learned friends say, well, they only found out once we started, our client, respective respondents started responding, who in fact is responsible or may be responsible for the payment. That cannot be taken seriously with respect, because the founding affidavit has a whole entire section that deals chapter in verse with the law, with the pension fund law. So on what basis does the founding affidavit contain a section like that, if it was only for the first time when our client started responding that the applicant became aware of this? And when it became aware of it, why didn't they withdraw against all of us, all of our respective clients? I mean, my client now has to answer a different question. I accept that. All right. So another important...
Your client, it's
the president.
The president.
Yes.
Prayer 3.
This idea that he must set up an inquiry either akin to or in terms of section 12(6) to investigate a retired NDPP. Well, so my lady, the applicant's attempt to characterize the events of 15 December when Advocate Batohi withdrew from the Nkabinde Inquiry as the triggering event for its application cannot seriously be sustained. The upshot of this very submission is that was always the idea that she was retired was known or reasonably ought to have known. There was no impediment pleaded for why she may not get her pension. So the idea that you retire, you get your pension ought to have been foreseeable. So that, whether it was formally announced on the 12th of January or was it, it's neither here nor there. Because why wouldn't she be? You would have foreseen that. On the letters, we are told that, well, the second consideration, let me be disciplined in submission. The second consideration is what we call an unacceptable delay after formal notification. So formal notification was on the 12th of January this year, where the applicant, together with all members of parliament, were formally notified that the second respondent would receive her pension benefits. Her pension benefits, I guess, I don't know how to phrase that. Now, we understand the argument that, well, it was common cause that the second respondent would conclude her tenure on the last day of January, which is the 31st, okay? It is also common cause that at the very least, I don't purport to speak Afrikaans, but I like the color. Op die swakste, they would say in Afrikaans. The 12th of January, which we don't accept in any event. Now, what does the applicant do? The applicant takes...
Triggering event, was it announced on the 12th of January 2026?
Yes, this year.
The second respondent will receive her pension
Yes,
payout.
but we don't even accept that. We think it's clutching on straws. That's why we're calling it at the weekend. What is that? At the very least, you know, my learned friend doesn't know how to speak Afrikaans, and I don't like it. But we don't accept the 12th of January. It's just really clutching on straws. But let's accept it for what it is for a moment. It is known that Advocate Batohi is finishing her tenure on the 31st of that very month. The applicant waits 18 days to do anything about it. So the applicant writes a letter to the president on the 30th of January, one day before Advocate Batohi is to vacate office, and says what the letter proposed to say: set up an inquiry, withhold funds, etc., etc. That letter also demands of the president to respond not on the same day, not the next day, on the 4th of February. I pause. By then, the proverbial horse had already bolted. Advocate Batohi was on retirement. So it is correct, the legal principle was correctly postulated by my learned friend for the applicant, that a litigant cannot be criticized for seeking to avoid coming to court urgently by engaging the parties.
Yes, but the period of engagement
Must be reasonable.
must reflect
Yes.
the urgency.
Yes, absolutely. You have got to be reasonable. You cannot seriously stand up and tell this court that a day before Advocate Batohi was to vacate office, we waited 18 days. Then the day before, we write a letter to the president and say he must respond after the event. What is that? It can't be. Now, so I was saying that the principle is correctly postulated by my learned friend, but its application falls short. It's unreasonable for one to tell a court, I was trying to avoid coming to court in circumstances where you yourself took so long and the demanded response time is it's after the event that you're trying to, anyway, I've made the point, I think. Now, courts have consistently refused, as I have said, to countenance an urgency that the party has brought upon itself.
Yes.
I will refer your ladyship to the case law, but the principle that they make is what I just submitted on.
Yes.
So it's the Castello Property Limited, and that your ladyship will find in case lines at 007
Yes.
246.
Thank you.
And then the second case is again about my client, is President Cyril Matamela Ramaphosa and others. It's a 2025 decision that I referred your ladyship to earlier. So where are we now? My lady, the applicant tells us that it waited 18 days because it wanted to exhaust other avenues. I don't know what those other avenues are. As far as I understand the applicant's case to be, that avenue is the letter to my client, written a day before Advocate Batohi was to vacate office, and response to which was demanded days after she had vacated office. Beyond that, I'm not told of what these other avenues may have been. So that is to say that there is no detail provided as to what other avenues were pursued, when they were pursued, with what result, and why it required a further 18 days after the formal parliamentary notification, especially in circumstances where it was known that Advocate Batohi's exit of office was imminent. So that's the second consideration. I promised three. I always promise three things. The third consideration is what we call the inadequate explanation for the delay. Takes us back to what Rule 612 requires. It says, the founding affidavit must explain why there is no relief later. This is to tie it back up.
Oh, that would be a substantial redress.
Yes. So I have made the submission, I just brush over it actually, which is there's an assertion here that pension payments would be irreversible once paid to the second respondent. We don't know on what basis, legally or otherwise. That's just an assertion that is made in the paper, so I've made the submission. Now, back to Justice Tuchten's judgment. A further consideration, to the extent that this court is of the view that the first hurdle has been overcome, which is not my client's case.
Yes.
One of the considerations is prejudice to the respondents, and I will deal with that immediately.
Is this now the time that was given to answer?
Well, no.
Not.
Prejudice is a lot more than that, because it's a factual inquiry, remember?
Yes.
So one of them, yes, is the time provided to answer. The second is, one has to weigh up the prejudice to the applicant as well, which is important for a court. And as we understand the applicant's case, it has to wait to have its matter ventilated in due course. And that's why it wants to come here urgently. Your ladyship will see why we argue that way in a moment. Now, the applicant tells us that the court rolls are long. The court is too busy in the normal course. There is trial or hearing allocations to 2030.
No.
Well, that's in the papers. I promise I'm not
I
making
sit
it
in
up.
this court, up until today, I sit in this court regularly. Opposed motions, the dates are now allocated in June.
We're in March, June.
Yes,
But-
the trial role is a problem. But in respect of unopposed motions, that was somewhere in May. And in respect of opposed motions, that's somewhere in June. So that backlog has been cleared up.
Oh yes, I stand corrected. The founding affidavit does say trial, but doesn't say anything about motion court rules. That we now know is in June. All right, so all of this may speak to inconvenience. I don't want to wait. Now, what is the contrast? Multiple organs of state, including my client, naturally, are brought here on an urgent basis to answer papers on any number of topics. And it is quite relevant that notwithstanding the fact that the founding affidavit carries a whole section on the pension fund law, relief was sought against my client to withhold the payment. My client doesn't pay pensions. The law says so itself. It is a board of trustees. The applicant
That
ought
is
to have
so.
known that because it has chapter and verse in the founding affidavit. But that's not what happened. My client was brought here. Relief number 2 says, don't pay. I don't pay that. So now my client is compelled to answer that on an urgent basis, okay? That's number 1. Number 2, public administration must come to a pause while we engage here. And that implicates many organs of state. The Minister of Justice is in court, the NPA was cited initially, and so it goes. Now, this is all done, my lady, at the public's expense, which is very ironical in this case, because the application is brought to court under the blanket of protecting the fiscus. Yet it has had the exact opposite effect on the fiscus. So far, at least. My learned friend will invariably speak on behalf of his client, but the prejudice to his client is immediate, direct, and personal. She's done her tenure. She must now wait on the basis of untested allegations to receive her pension.
Is this? Yeah,
Sure, I will say no more on that score. Now, the institutional prejudice, my lady, would be the displacement of truly urgent matters that could simply not be accommodated today, because this case was accommodated today. So to sum up, case is not urgent. The first hurdle has not been satisfied. If your ladyship is minded to find that the second hurdle has been satisfied, the other consideration are weighed against the applicant. And those are the submissions.
Thank you. The button.
As the court pleases, my lady, I will attempt not to repeat what my learned friend for the President has said, but there will inevitably be some overlap. My lady, we make 2 submissions. Firstly, that the application is not urgent, and secondly, to the extent that there is any urgency, it is self-created. So as to the first submission, that the application is not urgent, we have dealt with this fully in our heads of argument at paragraphs, we have paragraphs 9 to 27. I'm not going to take your ladyship through all of that. I do need to summarize what is said, the relevant, most material points there. We submit that the applicant has failed to establish at all why it cannot obtain substantial relief at a hearing in due course, which your ladyship has just told us would be June. Well, it could have been May if this application had been brought a month ago. We could almost be there. It's failed to establish why it can't obtain substantial relief in due course. It has not put up a single fact to show why it cannot obtain substantial relief in due course. And that is the foundation point of urgency. If you can't show that, you're out of it. There is nothing about this matter that brings it within that framework of no substantial redress. We say there is no evidence. All we have is an assertion that, well, it may be difficult to pursue the money later. Well, it may be difficult and it may be easy. That's speculation, and that is surmise. Speculation and surmise do not give rise to urgency. Facts give rise to urgency. There is no single fact on the papers which shows that there will be any difficulty in collecting the money afterwards. In fact, milady, it goes further than that. The applicant, my learned friend, cheerfully used the word dissipation in his submissions. The applicants have said we don't rely on dissipation. And can I just take your ladyship to the relevant passage? It is page 001, 62. 62. Paragraph 267 at the foot of that page.
Just a moment. Case lines is just, there we go. Which paragraph?
Paragraph 267, my lady, at the foot of the page.
Thank you.
This is what the deponent, Mr. Van Rooyen, says. He says the applicant does not allege, nor need it allege, that the second applicant intends to dissipate the funds. So that's the end of the matter. They say we're not concerned about dissipation. Well, then what are we doing here? We're doing here because it may be difficult, apparently, to get the money back. Well, why and how and so on, but there's no issue of dissipation. And we deal with this, and this puts an end to the no alternative relief or the alternative remedy, or no relief in due course. Can I also refer your ladyship to what is said in our heads of argument at paragraph 54? And I'd like to take your ladyship there directly, because the law in this regard is quite clear. Is your ladyship with me?
And you may proceed. It's paragraph.
Paragraph 54. I'll just read 2 paragraphs, maybe.
It's your head 00.
I don't know the paper. 623, my lady.
Yes, just a moment.
This is what we submit. We say courts will ordinarily not come to the aid of a party seeking to interdict the payment of funds, precisely because there is a presumption that a claim in damages, or in this case recovery proceedings, will arise in the ordinary course. That there's a very limited range of cases in which the court does come to the aid of a party seeking to interdict payment of funds. Those are the anti-dissipation cases. It's a sui generis.
We're not dealing with them.
We're not dealing with that here. And the Supreme Court of Appeal has held, paragraph 56, in paragraph 56, as follows: the requirements for an anti-dissipation order of this kind, in addition to satisfying the ordinary requirements for an interim interdict, are first, a claim against the respondent, which is in dispute, but secondly, the respondent is intentionally secreting or dissipating assets, or is likely to do so, with the intention of defeating the applicant's claim. That's what the SCA has said. The MKA says we don't allege that. Well, that's the end of the matter as far as that's concerned. We say there is a high threshold, and precisely because there is ordinarily an alternative remedy to recover the money. You can sue. And so that really, milady, is the end of any so-called dissipation argument. The facts, no facts to allege any basis for a fear that it will be difficult. No facts to show there will be substantial delay. We know from what your ladyship has said, it's June, 3 months from now. If the applicant had brought interim relief proceedings in the ordinary course in February, let's say we allow them, forget the other delay questions, if in February, the matter could be heard on the ordinary roll in May, 2 months away from now. But instead, your ladyship is burdened in the urgent court, and other cases are squeezed out of the urgent court. If they had brought interim relief proceedings in the ordinary course, they could have interdicted all future payments from that date, so that some remedy is available in the ordinary course. The only risk of loss is that from February or March to June 2026, monthly payments would already have been received.
Now that is that stated in the papers? Because I was thinking, has it already now? It makes sense because it's monthly payments.
It's monthly payments. I think there is also a capital sum which is paid when a pension is paid out, but I shouldn't speculate, I don't know. But you know that the essence of a pension is monthly payments. You pay in, the state pays in, and then you get a monthly income. Whether or not there's a lump sum payment. So all that will be lost, all that would have been lost, in inverted commas, if the application had been brought in the ordinary course, is possibly a few months of monthly pension payments, and that could be recovered in due course. And so the point actually emerges from the case on which our learned friend relies, the Polori case. That was not an urgent application, it was brought in the ordinary course. You can do it, and you can get relief. And if you lose a few months, well, then you've got a remedy. So, milady, the application is simply not urgent. The foundation is lacking, namely that they won't receive relief in due course. They could receive relief in June, or could have received it in May, if they'd acted properly and acted sensibly. But they refused to do either. Then, milady, the second point is that the urgency, any urgency that there is self-created. Can I take your ladyship to page 001, page 34?
Yes.
Your ladyship will see paragraph 54, 2/3 of the way down the page. This is what the deponent says. Your ladyship with me. So, I'm sorry. Paragraph 54. This matter arises against the backdrop of the applicant's long-standing concerns relating to the conduct and tenure of the former NDPP. 55. While such concerns existed historically and in varying forms, they had not previously assumed a definitive or legally cognizable character. Paragraph 56. The position materially changed with the establishment of the Nkabinde Inquiry, a process in which the former NDPP actively participated and in which she testified. Paragraph 57, the critical paragraph, it was during the course of her evidence before that inquiry that the applicant's concerns crystallized. That's when they knew when it crystallized. Their long-standing objection now had crystallized. The last date that could have been, my lady, is the 15th of December 2025, because that was the last day on which Advocate Batohi gave evidence. She gave evidence for about 10 days before then, but the last day was the day when she left the inquiry, 15 December 2025. So from that date, the applicant's concerns about her had crystallized. From that 15th of December 2025, they took 2.5 months to move this court. End of February 2026. They took 2.5 months to attempt to move this court in respect of something which had crystallized in the middle of December 2025. And that's unexplained. What happened? It's unexplained. We are told two things happened. Firstly, Mr. Van Rooyen says in his affidavit, I got an instruction on the 12th of January to take this matter up. Well, that was a month and a half before he launched the application. What happened? We know what happened in that month and a half. My lord, what I muttered to my learned friend, I apologize for creating the noise. It's the oldest trick in the book. When you are in trouble with an urgent application, and by the middle of January, they were in trouble with an urgent application which was already 2 months old, stale, 2 months stale, from I beg your pardon, 1 month stale, 1 month stale, from mid-December to mid-January. When you're in trouble with an urgent which you want to bring, and you know you're going to be in difficulty, you send a letter. You send a letter and you spread it far and wide, and you say, oh, well, now I've written a letter. And so now...
But surely if a matter is so urgent that it needs to be heard in the urgent court, the timelines for the response to the letter must comply, must follow the urgency.
Yes, that's right, my lady. With respect, that is so. It gets worse, my lady, because they send a letter of demand on the 12th of January, they don't get any answer. 12th, 10th. No. I think I'm right that the first letter was the 12th of January.
Yes.
Is that right? Yes.
Well, let's look at it.
My lady, if my learned friend would help me, just to try and help. I think what is correct is the first letter is 30 January, that's MKP 1-001-85. And then earlier I said 12 January, but that actually should be 12 February.
Okay.
That's the second one.
Thank you.
And I only worked that out because I saw in the letter there were references to February. So that those dates.
So in other words, there wasn't even a letter.
Until the end of January. On the 15th of December, their concerns crystallized. On the 12th of January, Mr. Van Rooyen received an instruction, and 2 weeks later, 2.5 weeks later, they sent a letter to the president. And then when they didn't get a response to that, and they still hadn't been able to bring their urgent application, 12 days later, they sent a second letter on the 12th of February. That's what is colloquially known as an attempted kick for touch. It doesn't get halfway to touch. It falls into the hands of the other side, because it is an old trick. You try to keep the matter alive, and you try to say, oh no, we only start counting from the date of the letter. And now they say, oh, we only start counting from the date of the second letter. But they've been delaying for 2 months by then. So, my lady, we say that trick doesn't succeed.
Well, 1.5 months at that
12th of, well, yes, 12th of February, well, 12th December to 12th February is nearly 2 months. To 10 January is nearly 1.5 months. So we say it is hopelessly out of time, and it just can't succeed. It's an undisputed fact that the applicant wasted 2.5 months before instituting this application, and then brought it on a few days' notice. It is a textbook example of self-created urgency. Mr. Van Rooyen says he was instructed on the 12th of January. He still waited another 1.5 months. My lady, this is... One doesn't want to engage in superlatives, but this is truly one of the worst cases of self-created urgency I've seen.
Worst or the best?
One of the most extreme cases of self-created urgency. You bring an application on a few days' notice after waiting for 2.5 months. You can't do that, my lady. The application should be struck.
Thank you. Yes.
My lady, I was requested by your registrar to move to the back so that she can come to the front. Could we have 2 minutes, please?
Yes, the court will
Thank you.
adjourn for 2 minutes or 3 minutes.
For the fourth and the fifth respondents, the Minister of Justice and the Director General, together with Mr. Mashabela. My lady, I'm not going to take a long time addressing your ladyship on the issue of urgency, save for the following narrow portion of it. That to a certain extent, I agree with my learned colleague, Ms. Muvangwa, that the merits of the reason why you seek urgent relief, to the extent that you say it's the order is sought urgently.
I agree with you.
Yes.
In a certain sense, one must look at merits as well, but not in detail into all these various legal principles that's applicable. Factually, it is necessary to look.
Indeed, my lady. Now, for the minister to say, why does the minister say it's not urgent? The point you're going to make is simply this. The reason why it's not urgent is because the only circumstances under which pension funds may be withheld is if the allegations, even if those allegations are unproven or prima facie, as alleged by the applicant, relate to anything that relates to financial misconduct. And I'll take the court quickly, the reason why we say that. We deal with this, just want to refer your ladyship to section 003, that's where our answering affidavit is, page 361, paragraph 40.
Just say it again, 003 hyphen.
3, let me just go to paragraph 44, because that's where, 40, where the point is made. Page 364. My lady, there we deal with the government pension law. At the outset,
that's the law.
That's the law, and it covers government pension law, and I'm also going to make a submission that the reason why we deal with it is to demonstrate that the monies or the pension benefits are not public funds, and the law says so. They are monies, irrespective of the allegations, that belong to the beneficiary. And the law in black and white tells the court, or anybody for that matter, when those monies or benefits may be withheld. Section 4 deals with who contributes. We deal with it in paragraph 41 and 2. In subsection 2, it says any person who on or after the fixed date is appointed in the service of the employer being the government, in the person, in this case, of the second respondent, Advocate Batohi. Then it deals, and then we deal in paragraph 41, who the employer is. The employer is, in this case, would be the Minister of Justice. Where do we get the authority for this? At the beginning of this section, we're dealing with section 1796 of the Constitution, that the minister constitutionally bears the responsibility, overall responsibility over the national prosecuting authorities, as well as over the National Director of Public Prosecution, the administration of justice. So administratively, she's the employer, she's the boss. And now we get to the reason why we're fighting. We're fighting over, Minister, you must not take any steps to process all the benefits at the occasion of the retirement of Advocate Batohi. Then allegations are made. Section 17 deals with, before we even go there, how the contributions are determined. And my lady, I'm saying this because just to make out the point that these contributions, because earlier on the court wanted to know whether a portion of the contribution is made by the state, and to the extent that it is made by the state, that portion then becomes a portion that potentially could be attachable for purposes of these proceedings. Our submission is not. A beneficiary receives pension, or rather pension contributions are deducted from the salary of the beneficiary, of the employee. What government subsidizes is a benefit. In everyday language, it's a discount that you get when you buy a piece of clothing and they say you get 20% off. That 20% off does not belong to the supermarket. The value attaches to you, accrues only to you. So where there is the debate about the ownership of that product, one does not say that to the extent that a percentage of that asset or product or goods was given to you by the benefit of the person dispensing it to you, then it belongs to that person. Firstly, factually, it's not the truth, or rather, it's not correct to interpret it that way. Secondly, the law tells us in section 21 of the pension law that
21, rate of 24.
Yes, my lady, what we've done now in section 8 of case lines, we've uploaded the pension law where we deal with pension.
Thank you so much, because that was important to me.
I beg your pardon, my lady.
Thank you.
Yes.
Oh, thank you. All right, sorry. Your ladyship would see.
So it was rather strange.
Yes, I thought something else is being said. But then before we go to, in section 17 tells where the contribution comes from. Section 21 regulates how the benefits shall be withdrawn. And
withdrawal and deduction.
Yes, and deducted. And they may only be deducted when they are by the employer, by the way. The law says only the employer, on occasion of a court order, where there are damages resulting from the liability, or rather the misconduct or criminality or fraud perpetrated by the employer, the employee, that has caused damage or loss to the employer.
But is that after there was a determination?
Yes, definitely, because that's when, so now, after there has been a determination, if we bring it to these proceedings, if we were to understand the application by the applicants, is that there are allegations have been made. In December, there was no time we had to come here because Advocate Batohi's term was coming to an end, and we did not want her to leave this, the service, or her pension payouts be paid before we determine the extent of those allegations.
But she retired, is it on the 31st of January?
Of January, yes.
And then she started receiving a monthly pension in February.
She has to put in a form, and my lady,
okay.
just to assist, the NPA is no longer, which is the third respondent, participating, but they've done something very useful. I suppose that's the strength of their answering affidavit. That appears in section 3, but I'll refer your ladyship particularly to paragraph 35 there. This is just a small form, a short form one-pager, which you complete in order to release the benefits. If one does not complete this form, the benefits do not get released. First and foremost, this form, there's nowhere on the form that says the Director General of Justice or the Minister must co-sign or approve.
I think it's established that, and I think that match, if I understood Counsel Mr. Primat correctly, is that it is the pension fund that must make
it is the
payment.
pension. But my lady, we are the respondents, and I'd like to just give an indication of the reason why it's relevant for us to make this, because the minister is the employer, and they.
Oh, I see.
Yes. And if your ladyship looks at it's a clause 5 of that form. It starts first with letters, or rather with numbers 1, 2, 3, 4. It has horizontal columns. 5 says the following. That's where, in the privacy of Advocate Batohi, is when she completes the form, if ever she gets to do that, she would then tick what's applicable to her, because this form goes to the pension authorities. In 5, it says the following, which is conditional according to it. It says, for debt deduction, an originally certified copy of a court order or a member's approval in writing for debt due to negligence, misconduct, or theft as per GEP law. GEP law says what? And then we deal with it in our answering affidavit. It says the following: the circumstances under which, I beg your pardon, not answering that is the section 21 I was referring your ladyship to,
Yes.
with the circumstances under which monies may be deducted. And then that is 21, sub 3, sub C. It says the following, I'll start with subsection 3. Notwithstanding the provisions of subsection 1 or any other law, the fund may, C, deduct any amount due by the member to the member's employer, in this case, the minister. And then it says what kind of money is that on the date of retirement, which is the case with Advocate Batohi, Roman numeral 1, any amount which is payable to the employer or the fund by any member in the employment of such employer, on the date of their retirement. Roman 2, any amount which has been paid to any member, pensioner, or beneficiary in accordance with the provisions of the law to which such member, pensioner, or beneficiary was not entitled. Roman numeral 3, the amount of any loss which has been sustained by the employer. Now, my lady, on behalf of the employer, we're standing here saying there is no such...
The moment that those amounts must be deducted
Yes.
is upon retirement.
Yes. The point we make here, my lady, is that the relief sought against the Minister and the Director General is to take steps or not take any step to facilitate the payment of these amounts. What we're saying to the court is there is no law that says the minister cannot do anything. Actually, the minister is not even supposed to be here because in law, the minister reads that letter which was not addressed to the minister but was addressed and copied to the department and says, well, as a state functionary, in the principles of FedShaw, that can't do anything unless I'm authorized by the law. I may only do anything to assist, if at all, what they are saying might result in the second respondent owing the department. The allegations before this court on the basis of which they seek urgency to be heard urgently have nothing to do with any of that. It's conduct that even though, and I will argue, give a huge, disclaimer, assuming that the second respondent is found to have been the worst NPA in the history, and then we look at the law. Will that entitle the minister to withhold? No, my lady, ever. Unless the allegations, and they've been put in detail in the founding affidavit, none of those allegations implicate anything financially. So it might result in something. It might result in you cannot be an advocate, as my learned colleague was trying to assist, because the truth of the matter is that there is no proper case before this court. But at the end of the inquiries contemplated in Part B, the inquiry to look at whether she's fit and proper, the inquiry whether she's misconducted herself.
Well, we are still on the urgency.
It's even worse than an allegation. It does not say potentially there might be financial implications in the long run down the line if the inquiry in Prayer 3, however way the court might direct it.
You said that this
Yes.
money does not belong to the state. It's
Yes.
not state funds.
I beg your pardon, my lady?
You see that the money, the pension that's in the pension fund, each individual beneficiary or
Yes.
the money in the fund is not state funds. It
It's
does
not state funds. No, these are not public funds. They are not paid for to you because you behave badly or you are good or you come to work in the morning early. They're paid because you're paid a salary. And that's why I started first with Section 4 of the pension law.
The urgency in this matter is, well, that will entail that the monthly pension must be stopped.
Yes.
That's what the urgency is about this. Well, I didn't understand it to be months, but in anything,
Yes.
be that as it may.
It's urgent because as they say,
Yes, the
according
monthly
to them-
payments must stop because those monthly payments is actually public funds.
it's not public funds. And it's not public funds because I stand here making a submission, because the law says so. And the applicant made submissions this morning, and your ladyship would look at, consider the founding of it. There's no way in there that says, makes out a case that these are state monies. And my lady, let's look at the Zuma judgment and why it implicated state funds. It's not state fund because it's automatic. Because at the end of some outcome of some inquiry, a determination is made that you are not supposed to have received that money. And in this application, there's no relief that says, pending the determination in Part B of a decision by the state attorney, well, if ever it's there, because we don't even know if the state attorney is paying. And when I say we don't know, it's because it's not in the papers. It's speculation free fall. The determination, if in Part B, the relief was stop the pension because upon the outcome of Part B, where we are challenging the decision to afford her state funding in the inquiry of in the Nkabinde Inquiry, in those circumstances, you might find that money she might have to pay back. We are not even there. By design, Part B is conditional, is contingent on something that hasn't happened yet. And that, my lady, that's where the urgency is.
Yes. Well, the urgent thought is for something imminent. We must stop something that's going to happen in a week, tomorrow.
Yes. It's the outcome of that thing that still has not happened, that your ladyship still has to grant in prayer 3. That might necessitate the circumstances that might make it possible for the minister to not pay the pension money. And we're talking, we don't know when. And my lady, this application is not urgent for those reasons. And it's not urgent because there is no proper case before your ladyship to justify anything at all at this moment. The whole Part C, where there still has to be a quantification, for as long as the applicant is hinging their entire saddle on prayer 3, which is final in effect, which is untenable, which according to their own prayer B, is contingent on something, and they cannot show a clear right.
Yes, I won't be going into
There
the
can never
merits.
be a case on urgent basis for prayer 2.
I hear you.
Those are submissions, my lady.
Thank you.
And my lady, just one last part of in paragraph 44, where we're dealing with the Pensions Fund Act, that applies not only to government employees, to everyone. That also deals with the circumstances that might entitle anyone to withhold. In fact, the pension authorities, it says there, in respect of any damage caused to the employer. There's no allegation in the whole application that Advocate Batohi or the second respondent we suspect, because we are at the realm of allegations, suspicions, and just allegations, that there might be, her conduct may have cost the department loss. And it's because of that subsequently, when that inquiry finalizes, we might need to, it's not there. Section 37D of the Pension Fund Act, 1956,
I
says...
think you're going into the merits now.
Yes. Thank you, my lady. Those are submissions on the issue of agency.
Thank you.
As the court pleases.
In reply,
Yes, please, Madam. May I just give your ladyship a reference before I forget? Your ladyship said that the urgent court role's intention is to stop something imminent. The 2-month window, which lapses on the 30th of March, when the pension fund, the form my learned friend mentioned, gets processed, needs to happen within a 60-day window from the date of the retirement. That 60-day window lapses from 30 January, 60 days, 30 March.
so where do I find that?
You'll find that at paragraph 391 at 001-77.
Paragraph 391.
391
At?
001-77. So that's the imminent thing we're trying to stop. That's why we're interrupting the urgent court and displacing other matters. It's to stop the processing of that pension by the time that the statutory limit for it to be processed comes into effect. But my lady, let me start with my learned friend.
Well, that was my question. When will these pension monies be paid?
Yes, I'm also aware that we're not addressing merits, so I'm very hesitant about...
No, that is very important.
Yes, well, that's
to the urgent.
No, I fully agree. Those are the instructions that we have, and that's what's contained in the affidavit. If any other party can contradict that, which we've not seen about the 60-day window, I speak subject to correction.
Was a letter written to the fund to ask the fund when will payments be made, asking the fund to give an undertaking that no payments will be made. Where do I find those letters?
Yes, my lady. Can I, if you just bear with me and give me a moment. Uh, 001-88. That's the letter to the president in which
I'm not talking about the precedent. I'm talking about the fund.
I'm addressing your ladyship on the exact inquiry. Your ladyship says to me, where's the fund cited?
Yes.
I'm saying to your ladyship that this is the letter addressed to the president, but in that same letter it's also copied to the fund and a demand is made of the fund. So I accept 001-88. I accept there's no separate letter to the fund, but this is a letter of demand that's made to all the parties who are cited in this litigation.
Thank you. You may proceed.
Can I just point out is that that's obviously made in respect of the presidency, but your ladyship knows the rules of interpretation and holistic interpretation of the document, and that's why it's important, my lady, that what is also said at 001-89, paragraph 34, and also 001-90, paragraph 38.
I see there's the first demand. Let's just see.
Yes, that's withholding.
Introduction.
Yes, I think I gave you that reference.
Let's just see. Allegations. I am running down. First
Yes,
demand,
yes. Are you
withholding
on
the payment of any benefits? So we know there are no benefits.
Yes.
And the establishment of a narrowly scoped inquiry.
That's the second demand.
The third alternative demand, payment must be made with prejudice to the state's rights
Yes.
of recovery.
Yes.
Additional demand of state parties.
Yes.
Is that where you want to refer me to?
Yes. Because remember,
Yes, just direct my attention to that specific paragraph.
001-90 under the heading additional demand of state parties, particularly starting in line 2, they shall not do anything to facilitate any payment to the NDPP until such time that the demands listed above
Just a moment.
are satisfied. And then if your ladyship turns over the page at 39.8 and 39.9, Government Employees Pension Fund, Government Pensions Administration Agency.
Yes, and this was on the 30th of January.
Yes, so the instruction was that and what is said by the deponent in the founding affidavit is the retirement
There's no
age.
indication when this payment would have been made in the papers. We do not know.
Well, my client's position is that no payment is made before the 60-day lapse. That's why we are in the urgent court before the 60-day lapse, which is the 30th of March. So that's the imminent harm that the urgent court is being asked to prevent. And I wanted to start with that submission because there was some debate with my learned friends about timing and so on. And I just want to clarify that that's the applicant's case.
Yes, thank you.
So may I then start with my learned friend, Ms. Chabedi, who took you to paragraph 44 of her client's affidavit at 003-365.
003-365.
Does your ladyship have it?
Just a moment. Yes.
And at paragraph 44 at the bottom of the page, it's actually very helpfully highlighted in bold by our learned friends that when there's the so-called right of recovery is concerned, the categories are at their widest possible categories. What's stated there in the second last line and the last line? Theft, dishonesty, fraud, or misconduct. So why that's relevant, my lady, and again, I'm not doing this talking merits, I'm only doing this talking urgency, is because if there is an allegation of misconduct, the question then becomes, how does the state repository respond to that issue of misconduct? Now, what my learned friend Ms. Chabedi says to you is that the minister is the employer. The minister and the DG, they sign this form, they facilitate the payment. And that's the exact point. How is it in good faith that a repository of state power can exercise what we say, even at its lowest form, is an administrative function to facilitate payment in the light of unresolved misconduct allegations? And the point that is being...
Do we know whether that form has been submitted, signed? We don't know.
We don't know anything because unfortunately and I don't blame my learned friends' clients for this.
Sorry, the minister and the DG, they don't sign that form. That was the intention of indicating that it does not come to them quite plainly.
That's not what I understood the submission to be, but I take what my learned friend says. But the point of the matter is that...
So you accept that the minister and the DG has got nothing to do with...
Well, it's difficult. It's difficult to do so because if you turn over the page in that same affidavit, 003-366, some very interesting language is used about the role to be played by these officials. Because what is said is that the facilitation of the exit would in the ordinary course involve completion of
Which
forms...
paragraph?
46.
46, thank you. The end of tenure, yeah. Yes, facilitation.
So the facilitation of the exit would in the ordinary course involve the completion of forms and other related processes aimed at exiting the official. In the case of the NDPP, all these administrative processes are facilitated by and from the officers of the NPA. I accept that. But the point of the matter, and as it relates to urgency, is that this facilitative process needs to happen within the 60 days. The challenge brought by Mkhonto Wesizwe...
Yes, but then do you agree that the minister and the DG has nothing to do with the pension payout?
Yes, indeed. In fact, there was a with prejudice letter sent to them asking if they would be cut out on the same process, on the same basis as the NPA. That's not in front of you because no response was received.
Let me just make a note.
Yes, my lady, indeed.
Yes, you may proceed.
Thank you, my lady. These benefits are contributions from the employer's salary, including contributions by the employer, and then administered on behalf of the employee by the GPF. That's the same page at paragraph 49.
Yes.
So the point of the matter is that even though our learned friends make it seem like the apparatus of the state don't have any role to play, what we can now accept under oath from the minister is that the NPA at the very least plays some or other facilitative role. And the question is whether or not the court, in circumstances where Mkhonto Wesizwe comes to you and tells you, stop this facilitation from happening in light of the fact that they are untested misconduct allegations, the respondent's argument that you should close your eyes to that and let that misconduct be untested, carry on. That's really why in the essence of the argument on urgency, what my learned friend submitted to you is actually supportive of Mkhonto's case on urgency, because it's asking the court to stop these facilitative processes wherever they may come from and whichever respondent is responsible for them. And the reason we know that is because state functionaries like the minister or the NPA or the president, whomever it can be, can't simply close their eyes to serious allegations of misconduct and say, well, go ahead and resolve it after the fact. We know that they are under an obligation to consider issues, for example, of misconduct, and where it's raised preemptively, to apply their mind preemptively so as to prevent the ultimate harm which MK tells you is going to eventuate if you just let this go away.
The president is not involved
No,
in
agreed.
paying pensions.
No, my point I'm making is a slightly more generic one, which is, if any repository of state power is under an obligation to ensure that no misconduct has occurred in order to facilitate the payment.
No, that's
Yes, but
something for the that may always be tested.
Yes, but what I'm saying for urgency, and remember, I haven't addressed merits in the way that my learned friends have sometimes veered into doing.
I will give you an opportunity.
Agreed, but thank you, I'm indebted. But all the point that I'm making is that that's what the interdict is designed to do, is to put in place the proper mechanism to test the misconduct allegation before the disbursement happens. And the collective position by all of the respondents is, it's not me, it's someone else, and collectively then becomes, well, this is ex lege. It happens automatically. Pension funds happen automatically. But I just cited to you from my learned friend's own affidavit the very provision of misconduct which acts as a stripper of the entitlement to the pension. So our learned friend's arguments in response to me or my client at least, that, well, these pension funds must just go ahead and tough luck or whatever the case might be because it happens ex lege is actually not correct. Because misconduct is one of the specified grounds upon which the employer has the right to recover or to take whatever restitutionary action it could otherwise take. And the point of the interdict is to say, don't wait for the payment to happen in future and then recover. Stop it now whilst you can stop it and before the form has even been processed in order to be paid. So with all due respect, my learned friend Ms. Chabedi makes the case for the interdict in the form that it's prayed for, at least prayer 2, obviously not the prayer 3, which is the inquiry interdict. And I'm grateful for that because it's that very facilitative role that my client doesn't know about, which is the subject matter of what the interdict seeks to stop. It was
That's why it's urgent.
Yes. And can I just say, again, I speak subject to correction by my learned friend, Ms. Chabedi, but I heard her to say that the categories are financial misconduct. The specific phrase financial misconduct was used. I read that quotation from paragraph 44, which I read to you earlier, as not containing that qualification. It's misconduct in its widest possible sense. And if your ladyship takes a purposive approach to interpreting that section, that must make sense. Because the employer, whilst obliged to make a pension contribution, must have a...
On the date of retirement. So on the date of retirement, that's now... It's already happened.
Yes, but the facilitation of the payment has not yet happened. We're in that 60-day window, which I was talking to you about at the beginning. So I accept as a matter of fact the retirement might have happened, but I'm saying that if the payment has not yet happened, and it's all contingent on these facilitative
You see, but
steps.
if the payment, I do not know. I do not know whether the payment's been made or not.
Neither do we. And I don't think that the applicant can be criticized for that because the applicant at the stage of the interdict, before the review and before it gets the review record, is, as the courts have recognized, litigating in the dark to some extent because it doesn't know exactly who the relevant decision makers are. So my client can't be criticized for that with all due respect. My client tells you the version it has about what it knows. It might turn out to be wrong on the merits of the review, but that's the job of the review court. At least for the purposes of the interdict, the imminent harm is what we've identified for your ladyship.
I agree with one counsel that made a remark, and it may be Ms. Mavungwa, that these are not difficult. The laws applicable to what government employees, what they are entitled to, the law pertaining to pension funds, and so forth. It's not difficult. So for the applicants to simply state we're in the dark, that is not correct insofar as legal principles are applicable.
Well, I mean, to the extent that the Pension Act says what it says, obviously that's a statement of law, and I'm not suggesting the defense to that is ignorantia juris neminem excuscat, as my learned friend was mentioning earlier. I'm not suggesting that at all. It's rather to say that even if the law is as it is in the Act, that does not prevent an applicant who comes to court to seek interdictory relief to cast the net as widely as possible, where on the other end, if I may finish, my lady, where on the other end of the coin, you end up with an Odacral type problem that if you don't cite one of the parties who might have been even tangentially implicated, whatever relief the review court can give you can be rendered moot on the basis that you didn't do Odacral or you didn't overcome the Odacral principle.
I hear you.
So, you know, it's like damned if you do, damned if you don't. And this is an applicant acting reasonably in the circumstances where information is not forthcoming and where it's trying its best to litigate reasonably in the public interest. So, my lady, that's Ms. Chabedi, if I may. Those are the highlights from Ms. Chabedi's address, which I'd like to bring to your attention. In respect of my learned friend, Mr. Budlander, Mr. Budlander said a few things that are repetitive of what Ms. Muvangwa said. I'll deal with that under Ms. Muvangwa, if you don't mind.
Yes.
There's just two things that I want to point out in respect of my learned friend, Mr. Budlander. The first one is that he made much emphasis of paragraph 267 at page 001-62, where he spoke about the applicant does not allege nor need it allege that the second respondent intends to dissipate the funds. And that was apparently made out to be that there's no dissipation case at all, and now the applicant is contradicting itself, or whatever the case might be. my lady, just read the affidavit, read the next paragraph at 001-63, which qualifies what that statement is about. It says at 268, the risk arises objectively from the nature of the payment and the absence of safeguards, not from any imputation of bad faith. So when we're talking about anti-dissipation in the way my learned friend suggested it, it's not anti-dissipation in the ether. It's that the applicant doesn't have to allege that there is a bad faith intention on the part of the second respondent to dissipate. But if the consequences are that the money is lost and it may become difficult to recover those funds, that's the purposes of the interdict. So I just needed to qualify that because that line of argument was advanced in front of you with some strength. And I would just say with all due respect that it's not as clear-cut as was suggested. The second point that my learned friend made with quite some force was this authority from the Supreme Court of Appeal in reference to when a court will not readily seek to prevent these types of payouts. I'll just quote from our learned friend's heads of argument at 006-24, footnote number 48, Knox versus Darcy.
Oh, yes.
Your ladyship will be very familiar with Knox versus Darcy. Can I just say that this is the emphasis I'd like to make. This is their authority. There would not normally be any justification to compel a respondent to regulate his bona fide expenditure so as to retain funds in his patrimony for the payment of claims, particularly disputed ones, against him. I would emphasize the not normally yes. situation. Because here we're dealing with a former constitutional office bearer, we're dealing with someone who is remunerated via state funds, and we're talking about someone who, despite a letter was being sent to them, asking them for different undertakings, didn't respond to those undertakings. The argument against me might be, well, she's under no obligation to do so. She's conducting herself lawfully. But there's not even a response to that letter to say as much.
The letter of the 30th of January?
Yes, that's right. If you'll see it, it's at 001.
No, I have had regard to
-94. That's the letter to the former NDPP. So it's not even as though we're in the world where they're saying, no, go away, here's the lawful entitlement to whatever. It's to keep quiet, and then when the answering affidavit is filed, to take all of these lawyers' points in the way that they are taken. But the very authority which they rely on...
Well, in the nature of litigation, an applicant and any applicant have regard to the answers in the answering affidavit.
And the litigation
and to
itself.
Decide, am I still on the right track? Should
Yes.
I go forward
Yeah.
on the footing that I started out with?
Yeah. Well, as against the second respondent, obviously the second respondent is implicated by all of the prayers because if the president starts the inquiry, she's the subject matter. You can argue that that's joinder of necessity. Obviously, the prayer to withhold the payment altogether directly implicates her because that's joinder of necessity. And then the security relief is also directly aimed at her because that's the alternative to say, if you get your money, just confirm that you are going to hold security so that if we come after you in future...
I'm more referring to once, because you indicated the applicant knew nothing. And they only started knowing something when answering affidavits are filed. So that is what I'm referring to. Now the applicant knows more.
Yes.
And decide with which relief against which respondent it wants to proceed.
Yes.
On an urgent basis.
Yes. Well, but that's why I gave the explanation in respect of the second respondent. The first respondent, the president, is obviously the 12-6 inquiry. But insofar as the other respondents have made it clear that they're not the pension payers, so to speak, you've heard me already in opening that even if that is the case, that doesn't mean that the relief that we seek to withhold the pension from being granted can't be granted today because the pension fund and the administrator have chosen not to participate. So I apologize if I misunderstood the question, but I hope my response to your ladyship... Okay, thank you. Now, if I can just deal with my learned friend, Ms. Muvangwa, very quickly, if I may. The first thing I'd like to start with, my lady, is my learned friend emphasized with some force the Mogalakwena authority. She read it from a different place, I think. I'm going to read from 007-30.
007-30.
So you'll remember my lady, Ms. Muvangwa, spent a lot of time talking to you about the Para 64 and what the analysis is and what the test is and all those kinds of things.
Substantial read.
Indeed. it's curious my learned friend didn't read out paragraph 65, because what did paragraph 65 do apart from letting that urgent application continue? Just listen to what it talked about municipal disbursements of funds and apply that to the pension fund here. Paragraph 65, 5 lines from the bottom. Where the funds of a municipality are disbursed by a usurper, recovery might be attended by serious problems and even be impossible. And Justice Tugton then, notwithstanding the criticism of urgency, delay, prejudice, everything else, concludes with, I find that the applicant has shown that it will suffer prejudice which cannot be redressed at a hearing in due course.
In those factual.
Yes, so let me just tell you what I think the emphasis of this paragraph is for 2 interrelated reasons. Firstly, as a matter of principle, we are in very similar circumstances to a municipality's funds being disbursed to a usurper, where the court itself recognized in the assessment of urgency that the difficulty and the problems arising with recovery might result in the money being lost forever. And we say that that paradigm applies directly to where we are, because we're talking about a similar placed pension fund. That's point number 1. On the factual inquiry, because my learned friend also said that urgency is a factual inquiry, and then we do that test about what's the substantial relief. Now, I'm not going to repeat myself, but you know what they are. SAPS, LPC, recovery. But that doesn't do well for my learned friend, the president, because the reason he's dragged to court today is about his obligation as the head of state and the head of the executive to discharge his specific obligation as against the former NDPP, not in some capacity as a potential perjurer, not in some potential capacity as a potential liar under oath and what that might mean for her as a legal practitioner, but qua NDPP, when she was sitting in the evidence box and giving that evidence at the time. And that's why the factual inquiry of the issues that my learned friend raised as the alternatives don't get her client out of the starting
public
blocks.
Funds?
I beg your pardon?
The money that is in the government pension fund, is that public funds?
It must be. Whether it's direct or indirect, whether it's by means of direct contribution or discount via refund, what no one disputes is that the state makes a contribution. The state money doesn't come from anywhere. That's some private source of income. That's all taxpayer money. And we say that the long arm of the law, insofar as ensuring proper payment of taxpayer funds is concerned, would apply even if it's by means of a discount contribution model or a direct contribution model. That's form over substance. The substance is whether or not the court can continue to use its supervisory interdictory powers to prevent the funds themselves from being disbursed.
I hear you.
So that goes back to my learned friend, Ms. Chabedi, who focused a lot on whether these funds are public funds or not public funds. But it applies as against all the respondents to the extent they ask your ladyship to take a hands-off approach and say, well, let's just let this payment happen and see what happens. And if you recover, good luck. And if you don't recover, well, tough luck. And that's, my lady, why we're here in front of you. So that's Mokgolakwena. My learned friend also emphasized with some emphasis Corruption Watch. Can I just remind the court what Corruption Watch was about? That was about, my lady, the entitlement of an unlawfully appointed NDPP by means of a settlement agreement to be paid out 10 million rand as settlement consequent upon the unlawful payment. We're in a totally different inquiry. In fact, my client's case is not that the right of restitution or the right of recovery doesn't exist. My client, which is what Corruption Watch may be authority for, my client's case is more nuanced to say that if your ladyship doesn't intervene now by means of the interdict, it doesn't matter whether it's unjustified enrichment under delict, whether it's a contractual claim, whether it's whatever form of restitutionary action you must take at that time, it's too little too late. That's why we're in the urgent court, my lady. That's why it applies as against urgency.
You want to preserve the funds.
Yes, exactly. Exactly so, my lady. My lady has the point. Now, there was this argument about is there the power or isn't there the power? And I'm just going to say this, if I may, and I'm not going to traverse the merits. The fact that, just let's take the facts. The fact of the matter is that the president, in his capacity as head of state or head of the executive, who has been recognized by no less than the Constitutional Court as the first citizen with ultimate responsibility for ensuring that the operation of the state happens according to the Constitution, says, I don't have this power because 2012-6 stops to a retired NDPP. But what he doesn't say to you, with all due respect, and maybe this is the argument on the merits, which I'm skirting away from, but I want to address it in the context of urgency. What he doesn't say, with all due respect, is that I can only act in terms of 12-6, and that I am so powerless in the absence of a specific act telling me I can do something or cannot do something, that I'm effectively with my hands tied behind my back, and this situation has to unfold. What we would argue, my lady, for the purposes of urgency, is that when the misconduct is raised in front of the president, serious misconduct is raised in front of the president, that the president's response to say, well, this is the only act that gives me some sort of power, I can't do anything in terms of this act, I must sit back and do nothing, is actually a derogation of duty and responsibility on the first citizen to use whatever machinery he has available to him to arrest pecuniary consequences flowing from that misconduct. And that's what my learned friend doesn't say in response to you, and I would respectfully submit that that's the basis upon which we look for the interdict. Because remember, what we're doing here is the interdict that's being sought is a pendente lite type of interdict. We know that the review is going to come. It's about arresting the immediate harm in circumstances where that harm hasn't yet fully eventuated, even if factually the retirement might already be in place. My lady, two more very brief points, if I may.
Yes.
We mentioned this in our heads of argument. I just want to give you the reference, if I may, to the judgment. It's the Glenister judgment, the one penned by Moseneke, DCJ, and Cameron J, as he was then. And the relevant paragraph I want to give you is paragraph 247 of that judgment, which I see does not have a case lines numbering on my side. Anyway, I'll give you the case lines numbering. Paragraph 247 of the Glenister judgment.
Yes.
Let me upfront say, I know that this is in an entirely different context. This was about whether or not the ministerial committee should be entitled to determine the list of specified offences or not. But the principle that I want to rely on coming from that judgment is what the court says here. And I'm reading from about 6 lines down. In short, ex post facto review, rather than insisting on a structure that ab initio prevents interference, has, in our view, serious and obvious limitations. In some cases, irreparable harm may have been caused, which judicial review and complaints can do little to remedy. And my lady, we say that's the exact territory that we are in. MK comes to you on the interdict relief to prevent the very kind of harm that ex post facto judicial review and restitutionary action may be too little too late to prevent. We're saying to you, whilst we're in front of you, your ladyship can grant the interdict to stop the payment from happening, pending the determination of all of those issues in Part B. And that's the world in which we're in, my lady. And it's simply no good to say, oh, well, go recover down the line or whatever, because the argument of the applicant, in light of the facts where the undertakings were asked for and no responses were given, is that the attitude, whether it's deliberate and tactical, whether it's choosing not to respond for choosing not to respond, keeps quiet and says, well, it's almost like defying you to defy me type of scenario. And so that's why we're in the urgent court. May I just also point out 2 things, my lady, regarding timelines and truncation and all of those things. You know, it reminds me of that saying, when the facts are against you, argue the law. When the law is against you, argue the facts. When both are against you, change the scope of the inquiry. And that, with all due respect, is what our learned friends are doing. Because remember what they say to you about the ordinary role for motions, is they say, oh, it's May or June or whenever it is. Bring your application then. But what do they say to you in the same breath? In the same breath, they say this application can never get out of the starting blocks because it's so legally incompetent. So you need to understand.
We'll go to the merits of the matter.
I'm only addressing it in the context of urgency. I'm not about to give you a defense on why that characterization is wrong. Instead, I'm saying let's do the respondents a favor. Let's adopt the characterization that the application is stillborn, if I can use that old-fashioned phrase, because it's legally incompetent. So their argument then to reject urgency, notwithstanding that there's a live dispute on the merits as to whether or not the inquiry can go ahead, is, well, come back in June. And really, my lady, that is the kind of tactical point scoring that one expects from respondents, but should not dissuade the urgent court to give effective relief when we're in front of you. Because not
if it's
only...
urgent, the urgent court
Yes.
will give that relief.
Yes, yes.
There's a good reason why matters that is not urgent, imminently, goes to an opposed motion court,
No.
because judges in opposed motion court has a lot of time
Yes.
to read, to research,
Yes,
to consider.
yes.
It is not possible in urgent court, and that is why it's a matter at all can be addressed in a normal course. Then it goes to the normal opposed committee.
For the purposes of the argument I'm making to you, I'm willing to accept that characterization. But all I'm trying to dissuade your ladyship from doing is to accept the argument about, oh, come back in June without more, in circumstances where their actual argument is, well, even if you come back in June, you won't get out of the starting blocks because this thing is so fatally flawed and legally
Then
dead.
the merits will be considered and not the urgency.
No, that's right. But as your ladyship also said in response to the respondents, you can't, it's not a peek into the merits, on the merits in toto, but it's a peek into the merits to the extent that there's a sustainable cause of action. And I'm saying if that's the threshold the applicant has to meet, that's the threshold the applicant has met, because no one disputes yes, the second respondent puts up a version regarding what happened at the Nkabinde Inquiry, but this court is not going to resolve that. All the parties take as common cause that there are serious allegations about the second respondent's conduct at the Nkabinde Inquiry and what may follow unless the interdict is granted. That's as far as I'll take it in the instance of urgency. May I also just, lastly on the issue of urgency, refer your... before I do that, I promised you the Glenister case lines bundle reference, 005-24.
005-24.
Oh, sorry. I get it. My learned friend has given me the citation in our heads to Glenister. That's not the actual case, Glenister.
Not a problem.
Thank you, my lady.
Heads of argument 005-24.
Hyphen 24, paragraph 102.
Yes.
And lastly, my lady, before lunch, where I intend to end at least, I'll just remind your ladyship of a matter with which you might be familiar, the matter of quick drinks. And that was the search and seizure and the customs and excise case. And in that particular case, the citation of Quick Drinks is Quick Drink Company Pty Limited and another versus Medicines Control Council and others, 2015, Volume 5, SA 538 GP. That was a judgment of your brother, Justice Collopin, before he got elevated upstairs to Bromfontein and not anywhere else. He got elevated to Bromfontein, and in the High Court, he granted an urgent application where there was a 5-month delay in the context of the claimed rule of law harm. So, and I say that because my learned friends quite correctly criticized the applicant and the conduct of the applicant drawing the timeline. It happened in December, then what happened in January, then what happened in February.
Yes.
And all I would point out is that it's not uncommon for an urgent court to grant urgent court full relief, even in the instance of a delay, because the true test is substantial remedy in
Yes.
due course. And based on the pleaded case of my own learned friends' clients, there's no substantial relief equivalent that can come from here, because all the equivalents they tell you about have nothing to do with the essence of this case. My lady, might I take an instruction? I'm
You
very
may.
indebted. Thank you, my lady.
I'm sorry to interject. My learned friend referred your ladyship to the conditions under which a deduction can be made from the pension. But you stopped short in reading the statute. Could I just take your ladyship?
I would appreciate it, thank
It's case lines 003 365.
you. And you're reading from?
I'm reading from paragraph 44. This is from the Minister of Justice's heads of arguments. In the answering, I beg your pardon, answering affidavit. Is your ladyship with me?
Yes, you may proceed.
What it does, she says, paragraph 44, section 37D of the Pension Fund Act says a registered fund may deduct any amount, and then it talks about when deductions can be made. And then at the foot of that page, your ladyship will see the passage which my learned friend read, in respect of any damage, which he didn't emphasize, caused to the employer by reason of any theft, dishonesty, fraud, or misconduct by the member, but he omitted then the final passage, final phrase, and in respect of which, one, the member has in writing admitted liability to the employer, or two, judgment has been obtained against the member in any court. Those are the conditions under which a deduction may be made.
My lady, with your permission, may I just also highlight the operating word there is the damages. Damages. Not the dishonesty qualifies the damage. The damages will then arise from the dishonesty there. But it's not the dishonesty that causes the justification for the withdrawal. It's where there's an instance of damages. And in all the submissions, pecuniary loss, that's all that's should be implicated before that decision may be made. As the court pleases.
My lady, before I have the last word, I don't know if Ms. Muvangwa wants anything to say either, because it seems like everybody's taking a second chance.
The court has heard my client submissions. I have nothing further to add. Thank you.
My lady, nothing that either Ms. Chabedi or Mr. Budland has said changed the thrust of my submissions in front of you. Thank you.
Thank you. It's lunchtime. I am going to consider all the submissions made by the parties, and I will at 2 o'clock decide whether the matter is urgent to proceed in the urgent court. Court will adjourn.
As it pleases. She was serious when she said she's going to make an agency ruling. It's not even like 1:30. inquiry prayer against the President. Then I will come back to the restraint on not making the payment. And then lastly, I will do the anti-dissipation security prayer and then costs. Although I don't know to what extent I'm going to trouble you about costs. So may I start with the President's powers, if I may? Now, my lady, the argument made against us by our learned friends, quite robustly, is that the President doesn't have any power because 12.6 only applies in the context of an incumbent and not a retiree. So, my lady, and I hope I'm being generous in saying this, the attitude of the respondents collectively is that the President can't do something about a now retired NDPP who committed the misconduct in the last few days of office. That effectively...
The words that are used is misconduct and fit and proper.
Yes, from the notice of motion, that's right. But what I'm talking about is that the conduct in question can amount to either misconduct or prohibition on fitness and propriety. That's the territory I'm in at the moment. And what I would say to you right from the outset is that at a principle level, that just doesn't sit correctly, at least with the applicant's sense of justice and public power, given the President's exalted status, to ensure constitutional conduct on the part of the state where he has a means and opportunity to do so. So the argument that there's no power we submit is the wrong...
accept that Section 12.6
applies to an incumbent.
Is no longer, it's not applicable.
It's never been the case that it has to be 12.6. That's why what is stated in the relevant notice of
Inquiry
motion...
in terms
similar to, yes. And I know that in the urgency argument, my learned friend Ms. Muvangwa pointed out to the Part B of the notice of motion, if I'm not mistaken, and said that that's, that somehow betrays the true intention and that it is 12.6. My lady, let me... and I think what she was pointing to, and she'll correct me if I'm wrong, is at 001-11 prayer 2 of Part B, where it says alternatively reviewing and setting aside failure to take a decision to establish any inquiry in terms of Section 12.6. Now, can I just upfront accept that to the extent that is a contradiction and an error, that's obviously a draftsman's error, and that we accept the draftsman's error. But to the extent that the facta probanda is necessary in order to make out the case for Part A at least, never mind what comes in Part B, because you will know Rule 53 means you can amend the notice of motion, you can supplement the founding affidavit, etc. What your ladyship will see from the founding affidavit is that there's extensive engagement with the question of holding the former NDPP accountable, even if the direct mechanism is not available. So, to the extent that the argument is made against us that 12.6 only applies to an incumbent, that's not controversial, with all due respect. My client's case is slightly adjacent to that. It's what do you do with someone who could otherwise have been disciplined under 12.6 and who now, by means of a retirement age, exits office. There's a hanging allegation of misconduct. Is the President empowered to do anything? And the argument from our learned friends that the President can't do anything because the only mechanism he has available to him is Section 12.6. And we say, my lady, that with all due respect is perhaps an overly narrow reading of the President's powers, insofar as the President having a wide remit to do various things under the principle of legality, provided it meets the rationality test. And let me give you two examples of that, my lady, if I may.
Yes.
The first one, which is referenced in our heads of argument, is the Masetla judgment. You'll remember in Masetla, the dispute was whether or not the President had an express power to terminate the services of the head of the spy agency at the time, and the Court ultimately resolved that the express power, which was higher, comes with an implicit power, or an implied power, or an ancillary power. The Court uses all that terminology to dismiss. And so to the extent that the President exercises a dismissal power that is not concretely sourced in an instrument, that would be lawful for as long as the president can show that his exercise of that generic power is subject to the principle of rationality.
It's a bit different, but yes.
No. I accept that the facts of that case is different to what I'm arguing. Instead, what I'm pointing to is this approach taken by the president, with all due respect, that there is no power outside 12.6.
So your submission is there's a wide power and this will fall within the wide
Your ladyship has it. Because if you had the ongoing obligation whilst she was in office to make sure no misconduct was committed, simply for the fact of the retirement can't strip you of any power to make sure that
What
those...
would the point be of this inquiry?
It must investigate whether the conduct in front of the Nkabinde Inquiry constitutes a separate ground of one of the listed grounds. In the notice of motion,
Yes,
we
and
specify...
Then there's the finding of misconduct, and then what?
And then to follow.
To follow what?
To follow. I don't...
Because misconduct within an employer-employee situation is to determine whether that employee should still be in employment. That's
Correct.
why I'm asking you the
Correct.
question.
I understand the point of the question. May I say, my lady, that even though both my learned friend Mr. Badlander and Ms. Chabedi in the first argument on urgency made much of that second portion of the 37D quote, which I didn't read out, the point that I would make is that that places the form over the substance. It might ultimately lead, following a misconduct inquiry, that if Ms. Batohi, Advocate Batohi, the second respondent, is found guilty of misconduct in the presidential type of inquiry that we're talking about, she might sign the admission. That it's the let me take you to the pleadings. I think that's going to be the best way to do it. I see your ladyship is looking at me.
So is it at the end of the day, is this inquiry then, although the misconduct inquiry
Yep.
is there to claim damages? Is that your...
No, that's not my submission at all. That's not my
So
submission
what
at
is
all.
the...
May I ask you to go to 003-365?
Just a moment.
Is your ladyship there?
Just a moment.
Oh, sorry, my lady.
Oh, there it is. Fine. 0.
003-365.
I am at that page.
My lady, right at the bottom, paragraph 44. That's the quotation that I was referencing. You'll remember in the urgency part there was...
No, I'm with you. Which portion do you want to refer
Yes,
me?
so all I'm saying, my lady, is that the
That is why I'm asking you
Yes.
what will be claimed. Because if you read the part in bold, in respect of any damage caused to the employer. Now, the employer in this instance will be the minister, the fourth respondent. So this misconduct inquiry, the only effect it could have on the second respondent's pension is if some or other damage was caused to the minister.
My lady, I don't read that as narrowly as you do, all my learned friends, with respect.
You don't address me because...
Yes. Can I demonstrate the two textual reasons why I don't read it as narrowly as my learned friends do? The first one is the word damage is qualified by the word any. So
Any
it says
damage
any damage.
caused
So-
to the employer by reason. So you want to define damage. It's not...
It's not damages, and that's the second textual point I was going to make to you, is that there's an attempt to read in pecuniary damages.
Okay, but if
the
it's
very
not pecuniary damages, then why should the money be kept? Because money is there to pay something that's pecuniary.
because that depends on the entitlement to receive the money in the first place.
Where do you get that from? Because I've tried to find anything in this act, and one was the president can't change act. It's an
Yes, of
act
course.
of parliament.
Yes, of course. No one is
So
suggesting
whatever
otherwise.
is found in this misconduct, it can only, the effect of that can only be determined in terms of the act. Now direct my attention to where in this act does it say that an employee will be disentitled to any pension? Because I could not find it, it might be there.
My lady, I would say if you look 2 lines above,
Yes.
when it talks about deduct any amount, and
Yes.
after the comma, it talks in respect of compensation.
Yes.
So that's probably the pension compensation. And it goes on to say textually, including any legal cost recoverable from the member in a matter contemplated in subparagraph 2,
Yes.
in respect of any damage caused. So,
No, let's just... No. I just thought you were going to show me the word disentitled, because what you're referring to are deductions. Let's just see. We find it right at the
yes,
start.
at the top,
To
yeah, B1.
deduct.
Yes,
Not to disentitle, to deduct.
yes, my lady,
In
that's...
any event, you say I should read it that it might, the fund, in terms of this act, may disentitle. Yes? No, proceed.
So the 2 textual points I was making was firstly about any damage, and secondly that damages are not stated there as narrowly as it is suggested. And well,
it says damage caused to the employer.
Yes.
You agree that the
Yes.
employer, and we've also looked at the act, who's the employer?
yes,
Who's the employer?
the minister.
So any damage that was caused to the minister,
Yes,
you agree?
Yes, but let's please not forget what we're actually talking about. We're not talking about damages caused by defamation or something of the kind. We're talking about financial damage to the employer on behalf of the state in allowing the disbursement of funds which the employee, in this case the former NDPP, might not otherwise be entitled to because of the underlying misconduct. It is the
You've
very...
lost me totally. Just repeat, because I need to follow you to properly adjudicate. We are looking at pension. We agreed.
Yes,
Pension is regulated by an act.
Yes.
You agree.
yes,
And we need to follow the act if
Yes.
we want to touch the pension.
yes.
So just repeat your submission.
Let's take it step by step, if we may. So, in the first instance, are you still at paragraph 34, my lady?
I do.
The quoted portion.
Yes.
Thank you, my lady. The first thing is you and I were having a debate about the word deduct.
Yes.
You were saying that the Act only allows deductions, and I was saying that that my interpretation, or at least my client's interpretation of the Act, is that the disentitlement would achieve the same outcome. Can I just link that to the word deduct before I move further
Yes.
on the rest? In respect of the word deduct, my lady, and I talk about disentitle, I think that's form over substance in the sense that what the section undoubtedly foreshadows is circumstances where the employer
Has suffered.
has suffered
By reason of misconduct.
we're going to come there with all due respect. I'm just dealing with deducted for now.
I'm a bit ahead of you.
Yes, my lady. I don't blame you. It's easy to get ahead of me, but I just need to take it step by step if you don't mind. So, form over substance, because what I'm talking about, disentitlement, is actually a deduction of the portion that is otherwise payable
Okay, there's
to
a
the
difference, you agree. To deduct something, well, I am going to get a pension of 100 rand.
Yes.
But I've broken a window, so now my employees say, wait, that window costs 10 rand. I'm deducting that because I suffered damages. You are entitled 200 Rand. No, I'm taking your entitlement away. There's a clear difference, and this is the last time, in my mind, between deducting something because of damages that was caused and a disentitlement. That is, you are not entitled at all to your pension.
Yes, and what, and I accept the point that your ladyship puts to me, is that deduction presupposes entitlement, whereas disentitlement presupposes no entitlement at all. And that's where we're speaking past each other, at least. I think that's where I think your ladyship is putting that to me. My lady, without repeating myself, I'm going to say that I don't think that that kind of interpretive work needs to be done in the way that it is being suggested, because effectively what
Well, the prima facie right must be found somewhere.
Yes, of course.
Yeah. Yes, now you may proceed.
Thank you. The point that I was making is whether you call it a deduction, in other words, your 100 Rand pension is being reduced by 10 Rand, the cost of the window, in your ladyship's world, is no different to what I say is that you are disentitled from that 10 Rand, which is caused by your misconduct, your breaking of the window. So the point that I'm making is that even though it says deduct, and I've used the word disentitled, a purposive interpretation of this clause...
You're not allowed to that 10 Rand.
You're not allowed to the 10 Rand. You're not allowed to that portion.
You're not entitled to
You're not entitled to the portion. And then how that relates to what follows after, because remember your ladyship and I were debating this concept of what is the damage, is that the damages are not... First proposition, the damages are not narrow financial damages only.
So what other damage could it be?
Well, look, for example, my lady, is what...
Well, let me understand you then correctly. So you're not looking for financial damages. You're not interested in money. What other type of damages do you want?
No, I think we're speaking past each other, my lady.
Just explain to me the damages that the applicant wants to claim. Will that be in money?
Yes.
Okay. Yes. So that must then be quantified. In
Yes.
terms of what
the actual sum might be.
What damage was caused.
You see, I'm hesitant to accept the way in
Well,
which your lady...
it's there in the Act. It's not that I am trying to think this...
No.
Looking at it, I'm reading the Act.
I accept that. I'm trying to make a submission, though, to your ladyship, with all due respect. The point that I'm making is an overly narrow reading of financial damages in the sense of pecuniary loss. So, for example, Party A caused Party B 10 Rand damage, and so the damage is quantified at 10 Rand as a consequence of that damage. That's not the species of...
I hear what you're saying.
Yes, thank you, my lady. That's not the species of damage we're looking at here narrowly. Because what you need to think about, with all due respect, is the employer has got a broad range of rights to protect the employer's interests. And one of the ways in which an employer can protect its interests, particularly in the realm of pension payments, is it might be a deduction of 10 Rand, or it might be a disentitlement of 10 Rand. But the breadth of the employer's
how would that damages be determinable?
Yes, my lady. It would be determined. That's why the notice of motion is structured in the way that it is. You would see that the Part B presupposes that there could be.
Yes. Okay, there could be. Yes. It is not at this stage possible to try and...
Nor does it need to be, with all due respect, because you are not going to be granting final relief here.
No, I'm quite aware of that, but I must be at least find that there's a prima facie
yes,
right.
Of course. But the prima facie claim is sourced in the right. It's not sourced in the quantification. Because borrowing that logic from your ladyship is that if I could source the right, and if I had quantification problems, that would defeat my claim at this stage. But that surely can't be correct if the source of the right has been identified. So all I'm trying to disaggregate, at this stage at least, is that the quantification question and debate need not detain your ladyship for too long, because there is provision for what happens in the event of a quantification dispute. All your ladyship is being asked to do at this moment in time, at least insofar as the restraint relief is concerned to prevent the payment is whether or not prima facie a case has been made out that one of those instances exist. We would say misconduct is the one that we would peg our colors to, with the consequence that if there is a prima facie case of misconduct to answer, then that strengthens the claim for the prima facie right for the purposes of the interdict.
Yes.
And I've heard your ladyship's putting the proposition to me, the difficulty your ladyship has with the way in which it's mentioned in the second part of the Act, where we are quoting from about any damage caused and whatever the case might be. But you've heard me. You've heard me.
I have heard you.
Thank you, my lady. So that's where we started from regarding the source of the power. But I had started originally, my lady, with talking about the president's powers, because I was talking about the inquiry.
Yes, but we agreed it's wide powers.
Yes.
That we've agreed
Yes,
upon.
and you've heard me on Masetla.
Yes.
May I just give you another case, which is a recent case from this division, which emphasized that same point. That was the Zuma case in the reshuffle decision. So your ladyship might...
Zuma versus?
Zuma versus President of the Republic of South Africa.
Yes.
The citation... My lady, I've got the Safley citation, so I don't actually have a report. I apologize
No,
for
the
that.
Safley reference I will read them at you.
Thank you, my lady. So the
Will suffice.
The Safley reference, if you just give me 1 second. Oh, sorry. I've got it. It's square bracket 2025
Yes.
ZAGPPHC, so that's this Pretoria High Court.
Z?
ZAGPPHC.
Oh, yes. Thank you.
1274.
1274.
And
Thank
it does have a Butterworth citation. Should I give you the Butterworth citation for what it's worth?
you.
2026, Volume 2. Butterworth's Constitutional Law Reports, 126 GP.
Thank you.
Thank you, my lady. And what your ladyship will remember is that the applicant in that case challenged the notion that the president had this power to place a minister on precautionary suspension. The nub of the issue was, according to the Constitution, you can only appoint or fire,
Yes.
and you've created this third category
Yes, yes.
of remedies available to you to place on precautionary suspension. Because it's not in the Constitution, ipso facto, that must be unlawful. That's the reasoning of what the applicant attempted to do there. And the applicant was unsuccessful, inter alia, on the basis that the court recognized
Wide
that...
powers.
Exactly. And that in the context, this precautionary suspension power is undoubtedly related to the express power. Now, why I make that point to your ladyship and why I say with all due respect that that is important is because here we've accepted what the express power provides for. 12.6 only applies to the incumbent. But we would say it is not an undue leap of logic or law, for that matter, to read into that express power an implied power for the president to continue exercising accountability oversight functions over a former NDPP, not forever and a day, but only in respect of whatever continued benefit they may have as a consequence of their office, in circumstances where the misconduct in question has to be resolved arising from that time in office. Maybe I should break it down step by step.
No.
You've
I know, I'm writing down. I'm just thinking whilst you're speaking
Yes.
whether I agree or not, but you might...
No. And we'll wait for the judgment to find that out, I suppose, my lady. But so the point that I'm making is that the whole nub of this debate doesn't simply rest on does 12.6 apply or does 12.6 not apply.
No,
It's the courts, no less than the Constitutional Court and this division, in comparable circumstances where you're talking about the president exercising powers at the highest level of state, is said to have these implied or implicit or ancillary powers to facilitate the overall objective of the express power.
Yes.
And-
What exactly does the express powers then entail? there will be an inquiry or investigation, and then what? What would be the end result of such an inquiry in terms of the express provision?
May we go there together, my lady?
Yes, yes.
If you go to 005-104,
Yes.
does your ladyship have it?
Yes, you may read.
Okay. The President may provisionally suspend the NDPP or a deputy NDPP pending such inquiry into his fitness to hold office, his or her fitness to hold office, as the President deems fit, and subject to the provisions of the subsection may thereupon remove him or her from office for the following grounds: misconduct, continued ill health, capacity, or on account thereof that he or she is no longer a fit and proper person to hold the office concerned. Now,
Okay, so that is something totally different. And that is why I'm trying to get my head around where we're going with this inquiry. It makes sense that while there's an employer-employee relationship, that section is very clear, to determine whether this person is still fit and proper to do the work. And the end result of that section is if you're not, then you are fired or you are removed.
yes, I accept that.
So this inquiry that you propose, or your client, is definitely not it's not similar to that provision, the express provision. It's not similar.
In this sense, because remember how the 12.6 inquiry operates is that the President doesn't have the unilateral right of removal. What the President's inquiry does is the President's inquiry sets out the 4-square fact-finding mission of, are one of the 4 requirements met that I've just read out to you, one or
Isn't
more of
that
those
an
requirements.
Nkabinde inquiry that's happening now?
Yeah, well, that's the irony. The Nkabinde inquiry into Mr. Chauke, Advocate Chauke, is a 12.6 inquiry, if I'm
And that
not
is to
mistaken.
determine whether Advocate Chauke is still fit and proper.
To continue holding the office, yes. We are agreed. But what I was saying is that the President sets the factual envelope, if I can call it that, and once and obviously he has a power of preliminary suspension or whatever, I accept we're not in that territory at all. But once he then does that, what he does is he sends that to Parliament, and Parliament then decides whether or not to remove or not remove on the basis of those factual findings.
No, I accept it.
The similarity we would submit is obviously not in the removal procedure or the suspension procedure. You can't remove or suspend someone who's no longer your employee. That's not controversial. Where the similarity is, however, is that the President is given a wide berth to determine an equivalent to the 12.6 inquiry.
What equivalent?
Look at what the Act says, my lady, with all due respect. It says, where I was reading earlier, pending such inquiry into his or her fitness to hold such office as he deems fit. So the point that I was making is the President is given a very wide hand to also determine the procedure of this inquiry and how it operates.
But the end result of this inquiry is to determine whether this person should still hold office. That's the end of it.
No, correct. And I've not argued otherwise. The point that I've been making is that the similarity under what my client is asking for is asking for the President to exercise what we say is an equivalent power to set up an equivalent inquiry that at least when that inquiry concludes does no more than what would happen under a 12.6 inquiry to establish if one of those 4 requirements are met. Because remember, only once one of those 4 requirements are met does Parliament or anybody else get the right to remove. So insofar as the procedural route is concerned, we say that that is the similarity.
But you do not want to, well, it's not possible to remove at all.
No, of course, but that's never been the case. And that's why I'm trying so hard, with all due respect, to disabuse the court of this notion that 12.6 is the only route.
No, why we have returned to 12.6 is because your submission was there's an express provision in an act. And because there's an express provision,
yes,
then we must, even after the the Act is no longer applicable to the second respondent, but because there's this express power that the President has, we must now say, but he has it afterwards as well.
Yes.
All I want to know from you is this is his express power. If we agree he may use it after the second respondent has retired, the type of inquiry is different. The reason for the inquiry is different. That's all I'm not sticking to 12.6. You may leave that. I'm trying to determine in what sense you say it is the same.
And I think what your ladyship, in the way in which you've summarized it for me, is actually very helpful. It's probably how I should have tried to articulate myself, is that obviously a 12.6 inquiry, after the inquiry occurs, if there's the sufficient basis to start the removal or whatever the case might be, that takes you down a different path.
Yes.
But what's the purpose of the provision? The purpose of the provision is to make sure that the person who occupies the office, whilst they are in office, doesn't commit misconduct, is a fit and proper person, and all those.
Yeah, okay. No, I hear you. Yes. Now, whilst in office, that I agree with you.
Yes, I'm just saying what the purpose of the provision is. I haven't even made a submission yet. My submission in response to that, however, is that if that is the purpose of the provision, setting up an equivalent inquiry is to make sure that the person who was in office at the time that the alleged misconduct occurred was in fact either free of misconduct or guilty of misconduct, depending on the outcome, because that has a direct implication on whether or not they continue to enjoy any benefit they had whilst they were in office.
Well, the only benefit is pension.
Yes, and so the point that I would make, based on the debate we had a short while ago, is that if the
It can't never be determined whether the person is entitled to pension money because of misconduct. We've both read that, but yes, let me rather leave you. You may proceed.
Yes, I think that's where you and I parted company, with all due respect. I think we...
No, but we've debated
Yes.
that. You may proceed.
No, of course. And all I want to say is that that's the difference, because I would say that that's the misconduct which qualifies under the deduction or disentitlement provision, and the mechanism to get there is via the equivalent 12.6 route.
Because
And that's...
if one reads your the relief claim,
Yes.
it refers to permanent. So you're going to be permanently deprived of your pension. And that's just a term to me that I...
In what part of the notice of motion, my lady?
Just a moment, I think it's 3.
I don't know if it's 001-5 prayer 3. I don't know if that's the one you might have had in mind.
Right. Oh, the respondent is to be permanently deprived of her payment of any pension benefits. That could never be the object of the inquiry.
Yes, but please look 2 lines above, after the comma, where the NPA Act abbreviation is given.
Yes.
So let's read together. Directed to establish an inquiry similar to 12.6, to determine whether the second respondent is guilty of misconduct and or no longer a fit and proper person, and then with the effect that if found guilty and or no longer fit and proper person, the second respondent is to be permanently deprived of her payment of any pension benefits, gratuities, etc.
But that's what I'm saying. If one have regard to the Act, and that is why we're going back to, remember this is pension monies. The Act applies to pension monies.
Yes.
No one can simply just, you are now permanently deprived of your pension if it's not in terms of the Act.
Yes, but that's why I would say that both, well, misconduct at least features both under the 12.6 provisions and the 37D. And it stands to a matter of reason that if you were no longer fit and proper under 12.6, you couldn't accrue any benefit from the office, occupying that office. So the point being is that if...
Well, you are going to be removed, yes.
Yes, and so the point that I'm making is that that's why we're asking for the equivalent inquiry,
Yes.
because the equivalent inquiry then is no longer interested in your tenure of office, obviously because you're no longer an employee, but rather about what are the benefits that you potentially enjoy from a completed tenure in
pension.
circumstances where there are questions such as your misconduct and fitness.
No. I hear what you're saying. I'm just saying benefits, we all know it's pension.
Yes,
It's pension.
yes.
You may
I don't
proceed.
think that's controversial at this point, my lady.
You may proceed.
Thank you, my lady. So you've heard me then on source, ancillary powers. I've given you both those judgments, Masetla and Zuma.
Yes.
And may I just give you two further quotations, if I may, my lady, if you'll bear with me, from both those judgments.
Is this still in respect of the wide powers?
Yes.
You may rest assured I've got that point and I will read
Okay.
again. You know,
Okay.
you don't
No, well, then if that's the case, I don't want to bother your ladyship.
I do have to
Can I just say? I think I gave you 53 and 54 of Zuma. Or did I not give you a specific paragraph?
You did not.
Okay, those are the specific paragraphs I want to give you then.
Just then 53
Of Zuma,
and
please.
54.
And also 91 of that judgment. Because ultimately, in the absence of direct statutory authority to do X or Y, we would say that the wide power can pass constitutional muster, provided you can demonstrate the legality rationality test, which is means and ends. And here the president...
And ends.
Yes. And here the president would have, in our submission, rational reasons to start the misconduct inquiry, because what he would want to do is make sure that Ms. Batohi was not guilty of misconduct or is not an unfit and improper person, with the end effect that she's entitled to a pension or not entitled to a pension, and then state funds are properly disbursed.
Gee,
That's the thrust of the president's powers argument, my lady.
thank you.
So that is that portion of what I have to say. May I then turn, my lady, to this question about, and I've dealt with this partially in opening during urgency, this ex lege debate that we had, and whether it's automatic or not automatic or whatever the case might be. I'm not going to repeat that. Your ladyship will be very happy to know. Two simple points then under the issue of ex lege and whether the interdict can be granted or not be granted. At least on the applicant's version, the payment has not been made. All of the underlying constitutive acts to process that payment, as far as the applicant is able to see, have not been done, with the effect that the interdict is sought to prevent those constitutive acts from being given effect, with the end consequence that the disbursement would occur. And that kind of interdict, a pendente lite style of interdict, particularly in the realm of exercising public powers, whether those are characterized as mechanic public powers or whether those are characterized as discretionary public powers, it doesn't matter. The fact of the matter is that you are acting qua public official. Anything you do is clothed by public power. And so the point is, even if you say it's ex lege, the court obviously is well positioned to restrain that where it says a case has been made to grant the restraint.
If the case is.
Yes. No, I'm not making any presupposition. Whilst I'm on that, can I just add two further riders to that, of course?
Yes.
It's helpful to have heard all of our learned friends say that, the minister doesn't exercise this power. It's just the signature of a form. The president has also said so. In fact, I think Ms. Batohi might have even said so. So we're not dealing with an interdict in the outer realm. We're not dealing, at least insofar as the pension payment is concerned. I understand that the issue in respect of the president is on a slightly different footing, but you've heard me on that.
Yes.
I'm just talking about the pension restraint at the moment. It's not some...
That would be prayer 2.
Yes. So I've done prayer 3 now, my lady. I'm now going back to the
Prayer 1.
prayer 2.
Prayer 2.
Yes, thank you, my lady.
We've done prayer 1.
Yes, prayer 3. To the best, I hope that I can.
We've done prayer 3, we're doing prayer 2 now.
Yes, my lady.
Yes, I wanted to know whom exactly must I now interdict?
If we are
Because
in...
you indicated, or your client, as
Yes.
appropriate.
Yes,
So who exactly do you want me to interdict now?
10th and 11th. Because your ladyship will see from line 1 of the prayer is asked in respect of 1st and or 3rd to 11th,
Yes, as appropriate.
as appropriate. And that we also addressed in the urgency portion this morning, that the fact that the pension fund and the administrator takes a supine attitude is at its own risk, particularly where in the notice of motion it's expressly stated the danger of your non-participation is will proceed unopposed.
Yes.
But my lady, I was still talking about that prayer 2, the pension prayers, very briefly. I was adding the 2 riders. So the first one is if we're in the realm of it just being signing a form, then it's not the outer standard that has to be met, because interdicting in that realm is about the clearest of cases, bearing in mind...
We are now referring to the 11th and the 10th and 11th respondents.
Yeah, well, in the circumstances, yes. Although, remember what we were debating earlier is that...
Now, I specifically asked against
Oh,
who
I apologize.
against who must I grant the interdict?
If you're with me on the interdict prayer, it would be against the 10th and 11th.
So in view thereof, you may then proceed to address me with regard to the 10th and 11th respondent.
Yes, so the first point I was making is that their restraint is not an outer type of restraint, it's lesser than that. In fact, it constitutes the lesser form of restraint that was dealt with in Precision Motors, which we deal with in our heads of argument, which says that if you applied the outer standard to all pendente lite type of interdicts against litigants, state respondent litigants in particular, you'd never end up with that kind of interdict, because that sets the threshold too high. Rather, what Precision Motors does, Acting Justice Hofmeyer in the Western Cape High Court, says that there's a bundle of conduct that is not as strong as original power exercising in terms of the Constitution or policy formulation or anything of that kind. It's the ordinary, and I'm using that in very loose language, it's the ordinary administrative acts, and to there it's the normal interdict standard that applies.
So it's administrative in nature?
Administrative in nature, yes.
Administrative in nature, and that is why the normal
yes.
interim interdict.
Yes. Now, I was adding, those were my 2 riders, but as a result of the debate that your ladyship and I are having, I need to address 2 further things, if I may. Obviously, there's some dispute raised by the respondents as to the actual categorization of the 10th and 11th, that one is a private entity and the other is not a private entity, and so that's a public entity. So on that construction of the argument, obviously the lower order administrative acts wouldn't apply as against a private entity. It would only apply as against the public entity. But I would say that's sufficient for my basis, because practically what it is the one is the fund itself and the other is the operator, administrator of the fund. As long as I can prevent one of them, being the public entity, to not be able to process the payment, that's sufficient
so
for me.
So are we now only with the 10th respondent?
Indeed.
Yes, you may proceed.
Thank you, my lady. So that's what I would say on the ex lege propositions, and why we nonetheless are entitled to ask for the interdict in the way that we do.
So now yes, you want to address me on the alternatives?
Yes, my lady. I'm happy to do so. May I just look through my notes to make sure I'm not forgetting anything? On the alternatives, my lady, the President at paragraphs 25 to 26 of the answering affidavit say misconduct issues may be pursued through the, I'm paraphrasing obviously, maybe, I apologize, do you want me to read?
No, you may paraphrase.
Okay, thank you. Misconduct issues may be pursued through the Legal Practice Council and criminal allegations through the SABC. And then they go on to say in the same paragraph 24, just one earlier, if the payments were unlawful, established restitutionary and legal remedies exist in order to recover the funds. I hope I'm not doing a disservice to my learned friends for Ms. Batohi, Advocate Batohi, but they say something similar about restitutionary or recovery actions at paragraph 67 of their answering affidavit, and they go one step further and they say the applicant may pursue review proceedings or recovery actions if necessary. And that's at paragraphs 177 to 178 of their affidavit. And the minister at paragraphs 84 to 86 also says something similar about these recovery actions. May I give three responses to these alternatives? I'm not going to repeat myself about SABC and LPC. You've heard me. In addition, in my reply though, and I will repeat that, at least in the context of the first prayer, as the third prayer as against the president, the inquiry relief, I said specifically to your ladyship that those alternatives are not sufficient alternatives because what's placed in issue by that third prayer is the president's accountability obligation that he has over the NDPP. The alternatives don't square up to that because they engage different inquiries.
Yes.
On the issue of the recovery action and the restitutionary relief, again, we've cited some of the cases in our heads about the difficulties that arise after the fact disbursements and so on. You've also heard me about the facts about why the recovery might be difficult because of the non-responsiveness, and be that as it may. But can I just add this further point, my lady?
Yes.
My client is not a state entity, obviously, and it's not one of the relevant state entities that makes any of the underlying decisions, which in the fullness of time may be subject to be impugned in Part B of the proceedings.
Yes.
The consequence of which is that it ill behoves the respondents to say of my client, well, just go institute restitutionary action or recovery action down the line, because number one, the same dispute that we're having now about what right does my client have to act in the public interest in this way is probably going to arise then, because my client doesn't stand directly in the shoes of the state in order to pursue those recovery actions. And in those circumstances, that's why we would say granting the interdict to prevent that situation from occurring is more in the interest of justice, rather than saying, well, you're not a state party, but go down the line and try and recover in due course if you can. So insofar as the existence of the so-called recovery actions and restitutionary actions, whether it's under delict or contract or whatever the case might be, is of no substantive importance to a person who litigates in the public interest, such as my client, because they don't have the direct right to recover. It's the state. At best, what's going to happen, assuming you're not with me on any of the prayers in Part A, other than Prayer 1, which is urgency, is that my client will only ever have a reactionary response to what the state either chooses to do or not do. And so at every stage of the entire recovery action or restitutionary process, my client would have to adopt the role, so to speak, as monitor-in-chief of all of the state respondents to make sure they're doing their job, as opposed to what my client comes to court now and says to you now, the payment hasn't occurred yet, there's no prejudice that's going to occur, grant the interdict and let them do their job like we say they have in law.
Yes.
That in the balancing act that your ladyship is obviously going to engage, that is the less worse option than saying let it all proceed and good luck to you in future to recover those funds if you ever can on behalf of the state. So the reason that the alternatives are not good enough for the purpose of the interdict is a question of sufficiency having regard to what the cause of action is. And the alternative relief inquiry then is not that any alternative might exist, it's about a meaningful alternative that gets you as close to or in as good a position as or better than the cause of action that brings you to court in the first place. And so we say that the responses about the existence of those alternatives, coupled with the ideas about restitutionary action or recovery action, is no alternative at all, with all due respect, my lady. I know there's arguments about the relief and is it competent or not. I think through the course of the morning, you and I at least have engaged that. I'm sure my learned friends will have something to say about that. I don't think I need to address you separately
Not
on
at this
that, my
stage.
lady.
You will have an opportunity in reply.
Thank you, my lady. I'm indebted. May I just look through my notes then, just to make sure that I'm done? Sorry, my lady, I'm just taking instructions whilst I'm doing it. My lady, 3 brief points, if I may. The first one is the argument put up that this would constitute a breach of the separation of powers. If your ladyship is willing to entertain, for the sake of argument, my argument around the 12-6 inquiry, then it's not a separation of powers, because what the court is doing is what courts ordinarily do, which is to either tell errant public functionaries to do your job, or if the errant public functionary has done the job badly or improperly or unlawfully, you correct them and tell them this is how you lawfully do your job. So separation of powers in this context, at least, is attenuated by what I've put to your ladyship. Obviously, if your ladyship is against me on the 12-6 equivalent, then there might be some purchase to the separation of powers argument, because that would take us into the territory of, is the court able to invent these other powers or alternative procedures or whatever. But our construction of our case is that that's never been what we've asked for. We've always asked for something related to the original purpose of the 12-6 power. So that's separation of powers.
Yes.
My lady, second last point, if I may, this question of the legal funding, because what you'll notice from the notice of motion is the legal funding doesn't feature in the Part A,
Yes.
but it does feature in the Part B. That's because we're going to have to wait for the review record from all of the respondents, and then we will tailor the relief accordingly.
I'm not concerned with
No, I think that's fair enough to say that. And that obviously goes, in the way that I say to you, you're not concerned with that, that goes some way to the arguments that are going to be made that the legal funding was perfectly normal or acceptable or whatever the case might be. With all due respect, I don't think we're in that territory quite yet. We're only in the world of what do we do about the pension, what do we do about the inquiry, and the anti-dissipation relief. Thank you, my lady. And whilst I'm there, can I just say that on that prayer 4, which I promised I would deal with, obviously prayer 4 is sought in the alternative to prayer 3. I'm at 001-5, my lady. I don't know if you have it.
Yes, thank you.
Thank you, my lady. It's sought in the alternative. So that's if you're against me on the 12-6. Well, then obviously any payment to Ms. Batohi has to happen.
Yes.
And then the question becomes about whether or not the second respondent is compelled or can be compelled to hold sufficient security. You heard me earlier when I gave you that reference to Knox versus D'Arcy, and that this is not, the situation we are in is a not normal situation. So we're outside that prohibition. And the second one is that the security will be
Well,
held.
if there's not going to be inquiry, then follows that there will not be an alternative to say she must keep the money safe.
No, I'm not sure
Let
I
me
follow that.
just repeat. So if the court find,
Against me
yes,
on prayer 3.
yes,
Yep.
then what?
Then prayer 4
Yes.
needs to be considered. That's at 001-5.
Let me just maybe look at it carefully again.
Does your ladyship have it?
Just a moment. press lines. Okay, let me try something else.
I don't have a clean copy, so I'm not going to hand up my manuscript where I just struck through prayer 3 in case you're against me.
But start reading so that I can listen.
Read prayer 4.
Oh, there we go. Thank you.
Oh, have you got it?
So in the alternative,
Yep.
that any payment but why, if pending what must this money now be secured or compelled to hold sufficient security for what? Pending what?
That's the prayer 4.2.
Yes.
Pending either the part B or the part C, depending on what
but
happens
if
in due
there's no
course.
inquiry, what does part B entail?
Part B, are you at 001-11?
Yes.
Okay. So the main prayer, paragraph 1, is if you grant the inquiry, but the inquiry exonerates.
Yes, you may proceed. So if I do not grant the inquiry, then this falls away.
That's why the 1.1 is important, because if you don't grant the inquiry and the inquiry is not established in the fullness of time, then the review moves to the failure to take a decision to institute such an inquiry.
Okay. Yes, you may proceed.
But we were talking earlier about how long the security is to be held for, and so we then move to the part B. I'm sorry? Were you saying something? Oh. My lady, so what I would say is that...
Of course, this is a conditional review and setting aside. Now, isn't that conditional upon the inquiry being appointed or the president being directed to institute inquiry? Because then you can only review and set aside. But
Yes.
if there's no inquiry, what do you want to review and set aside?
Look at prayer 2, please, my lady.
Which prayer 2 of this
Of the part B,
conditional?
are you still on -11?
I am.
That's how it moves. So,
Just a moment. It won't be for the first respondent at that stage to fail to take a decision, because this court will direct the first respondent to establish inquiry.
but are we now looking at prayer 3 in
I'm
that?
just trying to follow
Oh.
the first of all. Oh, you say that if I do not direct, then
Because that would mean the president has a free hand.
and if he does not,
Institute the inquiry, then that's why the alternative prayer is for a failure to take a
yes,
decision.
yes, yes. I hear you.
So how that relates then to the prayer 4 in the part A, which your ladyship was saying to me, is to what end is the security
yes.
held?
Now I follow you now.
That's then the end of the part B, whether it's the review exonerates or no, the inquiry exonerates or no inquiry at all, those two scenarios, as well as all the consequent decisions. And then the and or part C is included because if there's a dispute between the parties as to the actual quantum amount, then the part C will be used to determine quantum. Merits of the lawfulness of the claim would have already been settled in part B. And obviously, if we go down in part B, then part C can't arise. So that's the very way in which the conditionality of the review is structured. At this stage, it's setting out what are the different possible scenarios and outcomes, and how do I still continue to hold you accountable.
Yes.
So going back then to the prayer 4 of the part A, my
Now I'm
lady,
happy now.
then that's it. Lastly, if I may, just on the issue of costs. My lady, we've obviously asked for costs against any opposing respondent. The respondents have equally asked for costs against us. Costs is discretionary. I would think in these circumstances, the two appropriate costs orders are either that there is no award as to costs, not least because your ladyship has enrolled the matter as one of being urgent. So that goes some way to saying that it's not reckless or frivolous or anything of that kind. And you'll know that that's the exception under the BioWatch rule and affordable medicines. So if your ladyship is not willing to give me costs, certainly your ladyship must not give costs against me. But in that circumstance, your ladyship might be better tempted to say no order as to costs. And of course, if your ladyship is not minded to deal with costs at all, you can make it the review court's problem and say costs held over for Part B.
Thank you.
Thank you, my lady.
Yes. Thank you, Counsel. You may proceed.
Yes. I am.
Insofar as, yes, the first
For the
respondent,
first
that's Brave
respondent,
3.
the President. I will address 3 topics. I move in 3 topics.
Thank you.
The first topic that we will address under the rubric of Section 12 is that Section 12(6) does not apply to Advocate Batohi. I've listened to my learned friend. I will demonstrate to this court.
Common cause?
Well, I will demonstrate to this court why I need to address the topic nonetheless. So that's the first topic. The second topic I will be addressing under the rubric is that the President has no power to establish or at least to act in accordance with the relief prayed for. The third topic under that rubric is that the relief sought against the President is in fact at war with itself.
Is what?
It's at war with itself. It's incoherent.
Yes.
Now, why do I insist on addressing the court on the applicability of Section 12(6) to Advocate Batohi? Principles matter. The first principle of order comes from the Constitutional Court in My Vote Counts. The court was at pains to say that a party's pleadings, a party's case must be set out in its founding paper. It is for the first time, and I will take the court to those papers in a moment. It is for the first time that we're being told without equivocation that it is accepted wholly that Section 12(6) does not apply to Advocate Batohi. That is not the case that we answered. That is not the case that was dealt with in reply. That is not the case that was dealt with in the applicant's heads of argument. That is not the case to which we responded in the first respondent's heads of argument. If I could please invite the court to go to the replying affidavit. That's at 00421.
Just give me a moment.
Sure.
Zero,
4-21. So when I stood here in the morning, I discounted my learned friend's suggestion to the court that what is contained in prayer 2B was an error. The idea that what is contained in prayer 2B is an error is not supported by what comes afterwards. Now, the replying affidavit was filed after my client's answering affidavit. Paragraph 64 says the respondents contend that Section 12(6) of the National Prosecuting Authority cannot operate once the tenure of the NDPP has expired. That would have been the first opportunity for the applicant to say that was a typographical error. That was not in fact our case. But let's carry on. Then in paragraph 65, the applicant accepts that the respondents raise a serious objection. It doesn't say the applicant accepts that it doesn't apply to Advocate Batohi. It says the applicants accept that the respondents raise a serious objection regarding the literal post-tenure operation of 12(6). The applicant's case is not dependent solely on the success of the prayer seeking the establishment of an inquiry, and to the extent that that relief is further persisted with, it shall be dealt with in legal argument. This is the second opportunity where the applicant could have said, you misunderstood us. We're not saying it applies to Advocate Batohi. They say whether it applies to her is a matter for legal argument. We are here now. Now, 66. As appears from the notice of motion and founding affidavit, the release sought in Part A was expressly framed in the alternative. In addition to the relief directed at the establishment of an inquiry, the applicant seeks a preservation of the position pending the determination of review proceedings, and alternatively, relief directed at securing the position should payment benefits, and so it moves. That's the first reason why I insist, my lady, that this idea that there has been a different case pleaded and we misunderstood because it was a drafting error is not supported by what comes afterwards. But that is not all. If I could please invite the court to have regard to the applicant's heads of argument. The pinpointed reference where section 12 is discussed is at 00529.
Yes, paragraph.
Well, the section starts in paragraph.
I see, section 12C of the NPA Act.
That's correct, my lady. Section 12C, it says what it establishes in the context of the NDPP. The provision identifies specific grounds of misconduct, incapability, health, etc. 129, Section 126 of the NPA further incorporates institutional safeguards, etc. So it goes on and on. At no point are we told that actually we are not saying Section 126 applies to Advocate Batohi. We are told chapter and verse about how courts have recognized the importance of Section 126. Why? If it is accepted that it doesn't apply to Advocate Batohi, why are we told chapter and verse? Paragraph 137 says the statutory scheme does not expressly provide that its underlying accountability logic is extinguished upon the termination of the office. While the mechanism itself is framed around incumbency, the absence of an express lapse provision indicates that the purpose of ensuring accountability for conduct in office is not dependent solely on continued tenure. That's why, my lady, I need to address your ladyship on the inapplicability to Advocate Batohi of Section 12.6. Now, in light of what my learned friend for the applicant has argued, I will not spend as much time on it as I would ordinarily have, because we have provided full argument in our heads of argument,
yes,
and those your ladyship will find in paragraphs 32 to 37. Well,
I'm just having regard to paragraph 139 of the heads. In Nkabinde versus Office of the Public Protector, the court held that post-tenure entitlements must be assessed with reference to the manner in which office was held and vacated.
all right. So the Nkabinde case.
Just a moment, to treat departure as insulating prior misconduct from consequences. Yes, you may proceed.
The Nkabinde, so there's a distinction between this case and the Nkabinde case. That case concerned whether she was entitled to gratuities that were linked to her performance in office. That's wholly different here.
Okay.
So it wasn't pension.
Yes. I hear you.
Okay, I don't need to push it. All right, so we can close this for a moment, but we're coming back to it. So
that was the first. What case did we have to meet? You must make out your case in your pleadings.
yes,
That's the point.
absolutely.
No, I agree.
Yes.
I just want to know, are we moving now to a second point? Or are we still going to...
No. So all I'm saying on the back of that is to say that the case that my client was invited to meet was that Section 12.6 applies to Advocate Batohi. quite literally the case it was invited to meet. And that case, which has now been considered, is that it doesn't apply to Advocate Batohi. Although I listened to the debate between the bench and my learned friend, this idea that an inquiry should be established that is similar to, what does it mean to be similar to? We're still not told what that means, because the case was predicated on the applicability of that provision. All right. So our submission is that the scheme of that whole provision is inapplicable to somebody who has left office. I don't need to detain the court on that. We set fully out in our heads of argument and answer. The second thing I need to address the court on is this idea that somehow the president has preordained powers to hold former employees of the state accountable indefinitely, in perpetuity, is what I understand the submission to be. First of all, the applicant says in paragraph 51 of heads of argument, 00514, 51. This is now the case that was run here. The
Yes. '51, I do have it, thank you. The first respondent.
The proposition postulated, my lady, is that the president's role arises directly from the Constitution, no provision given, and it is not confined to any single statutory function. As head of state and head of the national executive, the president bears the overarching obligation to ensure that public power within the executive is exercised lawfully, rationally, and transparently. The test for any conduct to do so is not merely how it is presented alone, but also whether it can be justified under the rationality test in terms of the principle of legality. This is such a case where the president's wide discretion constrained by limited connection test is apposite. We are referred there to the Motau case, Constitutional Court case in Motau. Let's go there. I'm not physically going to take the court there, but I will discuss the case of Motau. The facts of Motau had nothing to do with somebody who had vacated office. Facts in Motau actually had something to do with somebody who was in office, and it was about the minister's ability to hold that person accountable.
Whilst in office.
Whilst in office. We were referred to paragraph 70. I had it a moment ago, but I think it's on my computer. Paragraph 70 is the authority relied on here. So the referred paragraph says, in the circumstances, it's under the rubric of rationality, against the backdrop of the fact that these people were still in employment. In the circumstances of this case, we are not required to determine whether the minister's decision was the best decision she should have made, or whether she could have made a different decision. Rather, we are concerned with whether the minister, not the president, responded rationally to the indications of widespread dysfunction in armed force under the leadership of these people, and whether her response was rationally connected to her executive oversight function. What is the oversight function of AMSCO?
Yes.
Now, I want to do one more thing. We have not been told what powers the president has, except in broad strokes, rationality, legality, what have you. But those, and first, sorry, before I move on to what I'm about to say, we were also referred to Masetla. And the proposition there was the power to appoint inheres the power to dismiss.
Yes.
That's right. But what is there to dismiss? Advocate Batohi is retired. It is correct that the president appoints Advocate Batohi, but she is retired. So Masetla doesn't apply with respect. Now, I keep harping on the fact that we have been given no provisions whatsoever. In Piccoli versus President and others, it's in fact these divisions, No, it's a constitutional court case.
Yes.
Paragraph 58 says, and I'll read from my note here, I'll get the citation now. It says, our constitutional court has held and has repeatedly reaffirmed that it seems central to the conception of our constitutional order that the legislature and the executive in every sphere are constrained by the principle that they may exercise no power and perform no function beyond that conferred upon them in law. Conferred upon them necessarily implies explicit powers.
Yes.
And that is exactly why my learned friend has been unable to refer us to the provision that equates the president to the role of a class captain at school or a head boy at school. It doesn't exist. Now, I promised to give you the citation to this Piccoli case. It is 1999.
Just a moment. Yes.
So,
Bracket.
SA.
Now, which bundle?
SA3. Well, I don't have it in a bundle. I just have the actual citation.
Oh, 1999.
SA
Yes.
374 CC. And the,
No, but 1999 has got bundle 1, bundle 2, bundle 3, bundle 4.
I will get the exact bundle for you.
Oh, you do not have it?
Yes, my learned junior will find it quickly. I apologize for that inconvenience. All right, so that is the legal framework that we must operate in. And within the context of that legal framework, the president does not have oversight powers over the NDPP besides what is provided for in the NPA Act and in the Constitution. It must be borne in mind, and my learned friend of the applicant correctly said, that the NPA is required to perform its functions independently, and that your ladyship will find in section 1794 of the Constitution. But then
then that one, and that's where we come back to section 12C, 6, where the president is giving, in terms of the Act, specific powers.
Correct.
Otherwise, that is the only power
Yes.
that the Act
Yes.
provides.
Because the legal principle is that if power is specifically given, then nothing else is given to you. But that's not all though, which is why the minister is in court today and able to speak, or at least her counsel is, and speaking. But the NDPP is also subject to parliamentary oversight. And the NPA Act under Section 35 gives us that law. So what is happening here? They function independently. You are to exercise the power that's given to you in law.
Yes.
Parliament is given oversight power over the NDPP by Section 35 of the Act. The President is given the power to appoint by the Constitution and the power to hold to account by Section 12(6) of that Act. The Minister is given the power to hold to account by Section 33 of the NPA Act, read with Section 1796 of the Constitution. So that is specific.
1796.
6, yeah, sub 6 of the Constitution.
Yes.
So, my lady, on the authority of the Piccoli judgment in the Constitutional Court, on the authority of applicable legal principle, power is given to you. On the authority of the power that is explicitly given to the President, on the fact that the case law that has been referred to is inapplicable,
Yes.
on the back of the fact that the applicant has not identified a single provision in the law that gives the President overarching power as akin to a dictatorship. The President has no such powers. So that's the second aspect of the 12(6) argument. First, as it doesn't apply to Advocate Batohi, that seems to have been considered now unequivocally in this court. The second is the President has no power to appoint
So
anything.
the so-called white powers, but
Yes.
you've discussed that with reference to the case law.
Yes.
Does not exist.
Yes,
in
it
these
doesn't exist.
circumstances.
Piccoli tells you that. Piccoli tells you that there's also another case
No,
that,
I have it.
that we cite in our heads of argument. The Western Cape Premier gives that principle as well. There's one more thing I wanted to do before I continued. I might come back to it later. I also listened to the debate between my learned friend for the applicant and your ladyship. And it brings me to the third topic, which is that the notice of motion is fighting with itself.
Oh, yes.
So in part A, I'm not going to take your ladyship to the notice of motion because we've now done that. Part A, we are told that, well, the court is asked to direct my client to appoint this inquiry akin to 12.6, okay?
Yes.
In 2B, well, I must be sure it's not one, I think it's 1B of the notice of motion, where it is postulated that if the president,
I think the part
Doesn't-
A, no, you may
No,
proceed. Just
sure.
part A is,
I want to give it its best version. If this court in fact finds that the president has no such powers,
yes.
we are told that in part B, his failure to appoint such an inquiry
Oh, I
will be
hear what you're
reviewed and set
saying.
aside. How can that be if this court says you have got no such powers on the authority of all the case law and all the legal principles I've set out?
So then he can't fail to take a
He
decision.
cannot, because he can't. He's been told you cannot. Unless he's going to be in contempt of court. And now we have another problem on our hands again. Because now my client is in contempt of court. He must go to jail. So that's the thing now on 12.6. On cost. We accept the submission by my learned friend for the applicant, Mr. Premit, that the court has wide discretion to grant cost. But we submit that this is not the kind of case where BioWatch applies. Because, quite frankly, the case that has been brought to court is on the merits, incoherent with itself. The litigation strategy was slapdash, as I have now demonstrated, where my client has expended resources answering a case just to be told for the first time today that in fact we're running a different case. One cannot conduct litigation like that. And unless I'm being told otherwise, no, those are the submissions from the first respondent for now, until later.
Thank you. Thank you.
Lady, there are 7 reasons why this application is without merit and ought to fail. But I'm going to focus on one of them particularly because it is a showstopper, and it's the Section 12.6 issue. If the President doesn't have the power to do what the MK party wants him to do, and then all of the rest of it collapses, and I'll show you what, Your Ladyship, why. And so I start with the Section 12.6 point, and perhaps I can just take Your Ladyship to the notice of motion briefly, so that I can show Your Ladyship why I say that it is a showstopper. And you then don't need to consider all the other things. If one goes, my lady, if Your Ladyship will go to the notice of motion.
Just a moment, Mr. Badlander. Trying to access case lines. Yes, I need to go to the notice of motion. I am there, thank you.
Thank you, my lady. My learned colleague for the President asked me just to mention to Your Ladyship that the Piccoli case is at page 005-382.
005-382,
382.
thank you.
So, my lady, if Your Ladyship then looks at the notice of motion, we start with Part A. Part 1 is the question of urgency. Para 1 is urgency. Para 2, the first and or third to 11th respondents as appropriate be interdicted and restrained from authorizing, approving, etc., payment of any pension benefits, gratuity payments, etc., over the page, pending the outcome of the inquiry in Prayer 3. That's the Section 12.6 inquiry. So if there's no Section 12.6 inquiry, Prayer 2 falls away because you can't grant an order pending something which doesn't exist. Then paragraph 3 of the notice of motion, part A, the first respondent be directed to establish an inquiry in terms similar to that of Section 12.6. If the President doesn't have the power to do it, then that paragraph falls away, can't be granted. Then paragraph 4, alternatively, that any payment made to the second respondent by the 10th or 11th be made subject to conditions, and your ladyship, with respect to ask the question, pending
Just
what?
a moment. I can't properly see. I must now look through this.
That's a great loss to your ladyship. I don't know how
I do not think it will be proper to respond to them. Yes. Thank you, Mr. Batman.
My lady, paragraph 4,
The alternative.
the alternative relief, your ladyship, with respect, correctly asked, pending what? This is interim relief. The only thing that can be pending is the outcome of the Section 12.6 inquiry, which can't be held, if we're right and if they're wrong. So the Part A relief all falls away. Then if one comes to the Part B relief, which your ladyship will find at page 00111,
That is relief that is not supposed, it's not before me, but let's just have a regard.
yes, can I just show you, ladyship, why everything collapses? Because prayer 1 is, in the event that the inquiry referred to in prayer 2 finds that the second respondent is not guilty, then etc., but there can be, if we're correct, there can be no such inquiry. That's irrelevant. Prayer 2, alternatively reviewing or set aside the first respondent's failure to take a decision to establish a 12.6 inquiry.
He doesn't have the power.
That likewise would fall away, and I'm not going to go through this. So the 12.6 inquiry is the pivot of the case. And if that pivot fails, then the case fails. And that's why I am going to focus particularly on 12.6. In the founding affidavit and in the heads of argument, the applicant says we want an inquiry in terms of Section 12.6. They say that 12.6 applies. We are told that, in fact, what the case they want to make is that a 12.6 inquiry must be implied. This must be implied into Section 12.6, the power to hold an inquiry in respect of Advocate Batohi. First observation to make is that nowhere, your ladyship will not find anywhere in the founding affidavit or anywhere in the heads of argument this argument that the power to deal with Advocate Batohi is to be implied, that it's an implied power in Section 12.6. Your ladyship won't find that made anywhere. It's a new argument which is raised here. And it's raised here. I'm not interested in technical questions about new arguments or old arguments. It's raised here because it demonstrates that the case is actually fundamentally flawed. And in desperation, the applicant has to turn to another way of articulating
If
it.
there's an express provision that you may appoint, then it's implied that you may also dismiss.
Yes.
Now, if it's an express provision that this can be done as long as this employee is in your employment.
Yes.
So they say it must be then implied that you can also do it if the person is no longer in your
Yes, but it's entirely at odds. What is to be implied is entirely at odds with what it actually says. Because what it says is you can deal with someone who's in your employ, and this is how you can deal with them. What they want to imply is to say it also means you can deal with someone who's not in your employ, and here's something different you can do with them. It's entirely at odds with Section 12.6. It's inconsistent with it, and you can't.
Yes, do something entirely different.
It's entirely a different subject, dealing with a different situation and dealing with different consequences. You can't imply that into 12.6. You can't imply into a statute something which is inconsistent with the statute or which deals with something entirely different. So that's the first point we need to make. This attempt at an implied power simply must fail. What implied powers are about is powers which are reasonably necessary for the implementation of the power you're actually given.
Yes.
This is something completely different. It's on our learned friend's argument, it's a gap in the Act. Well, if it's a gap in the Act, then it's a gap in the Act. Can't be filled by a court reading it into something which deals with something completely different. Secondly, milady, the power is alleged, so the power can't be derived by being implied. There's nothing, you can't read that into 12.6. Secondly, you can't find the power in the inherent powers of the president. And the
Just a moment. Yes, you may proceed.
The powers of the president are set out in the Constitution and the statutes. And Fedshaw tells us that a public office bearer, a holder of public power, can only do what is authorized. You can't invent another power and somehow say that that power is part of the president's power. Our colleagues say, well, the president's exercise of the power is rational, but that begs the question, what's the source of the power?
Yes.
The principle of legality, the Fedshaw case, says you must have a source
Yes.
of the power. Then all the other cases say, and Fedshaw, when you exercise the power, you must comply with legality.
Yes.
But legality is not a source of power. It's a restraint on power.
Yes.
And so the legality argument with respect also goes nowhere.
Just a moment. Yes, you may proceed.
My lady, the next thing I want to deal with is, also in the context of 12.6, is the interdict. Now, the interdict is now sought only against the GEPF and the Pensions Administration. The GEPF is regulated by Section 37D of the Pensions Act.
Yes.
And it says when deductions can be made from a pension.
And one cannot move away from that because it's pension money that's subject to the Act.
That's right, lady. And our lady, with respect, is correct that in any event, authorizing a deduction is not authorizing stopping payment altogether. But even if your ladyship was wrong with that, it wouldn't help, because none of the relief which is sought is capable of triggering 37D1B. What triggers it is damage, which we haven't seen, and secondly, most importantly, either an admission of liability or a conviction by a court, of judgment of a court. Now, there is nothing in any of this relief which will lead
Yes,
either...
you read those two, and it's
Yes,
on
I
the
read
next
them earlier.
page. So it is admission of
liability,
guilt, liability,
liability,
or an order of court.
or a conviction, or an order by a court. Yes, you've got to have one or the other, and neither of those will come from the so-called 12.6 inquiry. The 12.6 inquiry, or the 12.6, the quasi 12.6 inquiry, or the whatever you call the 12.6 inquiry, cannot deliver an entitlement to an interdict, because it can't deliver compliance with this section 37D1B, which is what governs the GEPF and the Pensions Administration. So that's the third reason why or a further reason why the 12.6 is a showstopper. Because if we are right on 12.6 and if the MKP is wrong, then there can be no interdict against the Pensions Administration. Finally, milady, before I get to some other remarks about 12.6, your ladyship, with respect, correctly asked, what is the consequence of the 12.6 inquiry which our learned friends are proposing? And can I take your ladyship back to the notice of motion? And then could you let you bear with me for one moment?
100%.
The section 12, the paragraph 3 of the notice of motion, page 001-5, says the respondent is directed to establish an inquiry in something similar to that of 12.6 of the national. Is your ladyship with me?
Yes, I
of
am.
the NPA Act to determine whether the second respondent is guilty of misconduct and/or is no longer a fit and proper person, with the effect that if found guilty and no longer fit or proper, the second respondent is to be permanently deprived of a payment of pension. Where does one find that?
Can't have.
It's invented. It's not in the Act. It's not in 12.6 as it exists. It's not in the Pension Fund Act. It's an Act that your ladyship is asked to determine that the President, by setting up an inquiry for which no provision is made in law, can say, I set up the inquiry, and if it finds you guilty, then you will be permanently deprived of your pension. There's nothing. It's non-existent.
I don't know whether this is important. It just, when we went back to urgent interim relief.
Yes.
But the relief in Press 3 is not interim.
Thank you, my lady. Leonard Jr. was politely nudging me to say the same thing. 12.3, paragraph 3 is permanent, is a final interdict. It's a final interdict.
I've just now,
It's pending nothing. It's final relief. That,
so
of course,
then other requirements need to be
then
met.
the other requirements have to be considered. Puts us in a different territory altogether. And it puts us in Plascon-Evans territory, because the normal Plascon-Evans rule then applies. And so, for example, Ms.
A clear right?
Clear right?
Because I've been debating with Mr. Freeman prima facie right. But there must be a
For
clear
prayer 3, there must be a clear right. And you have to find that clear right using Plascon-Evans where there's a dispute. And where Ms. Batohi says, I have acted honorably and professionally and lawfully at all times, I've done this, I've done that and the other, those are the facts on which that has to be determined. You can't establish the inquiry on any other basis.
Well,
So,
that is then the first, and I agree, I think everyone agree that the first port of call is then section 12.6.
12.6.
What powers seated in that?
Yes.
And in any event, if we move further on then the final interdict provisions.
They are predicated on a 12.6 inquiry taking place, or having to take place. And your ladyship will find the reference to this, the fact that paragraph 3 is final relief at 003-130, paragraphs 69 to 71. We've made that case. So, my lady, the section 12.6 case is a complete dead duck. No such power under the Act, no such power under the Constitution, no such power to determine these consequences, no such power to do what it wants. And that's actually the end of the matter. Everything else collapses as a result. What the we just need to bear in mind, your ladyship knows it's unnecessary to say, but let me say it anyway. The purpose of section 12.6 is twofold. It is to create the procedure for deciding whether to dismiss the NDPP and the power, and it is to regulate the procedure for the position in the interim while this is being considered. None of that has anything remotely to do with the person whose term of office has come to an end. It's a different subject. So it's incapable of applying. You can't apply it. I mean, Leonard Friend says you must imply it, but you can't apply it. You can't apply section 12.6 to a person who's no longer in office. So how can you imply it? It's invented. It's puffed out of the air. So the 12.6 inquiry, we say, is the centerpiece and pivot of the case. And if that fails, then the whole case fails. And we say that it fails, and it fails miserably. And one can understand why, with due respect, our learned friends are walking on hot coals, trying to say it is 12.6. Well, no, it's not actually 12.6, but it's like 12.6. Well, it's not actually like 12.6, but it's to be implied in 12.6. Dead duck, my lady. So that's with respect to the end of the case. Then, my lady, I don't really want to trouble your ladyship with long submissions about the other things. Can I just deal with the other grounds on which this case is hopeless? The first is that ground 1 is 12.6, section 12.6.
Yes.
Ground 2 is the applicant has not shown a prima facie right that needs to be protected. In order to get an interdict, you've got to have a prima facie right that needs to be protected. What's the prima facie right? It's the right to challenge the decisions of the pension authority. But the Constitutional Court in the Ota case made it clear it's not enough to say your right is the right to challenge.
Is it a prima facie right, or are we now faced with a clear right?
Well, it's a clear right in terms of establishing the 12.6 inquiry.
Yeah.
But in terms of the interdict, it's a prima facie right.
Yes.
And they say we need this because we need to do this in order to enable us to bring the review.
Yes.
And in Ota, the Constitutional Court said you can't do that. You have to have a right other than the right to bring the challenge. You must source it somewhere else. And if I can just refer your ladyship, I'm not going to read it to your ladyship, the hour is late. If your ladyship will have a look at our heads of argument, para 60, para 61, and para 62.
Thank you.
Then, my lady, the third ground on which this is hopeless is that the Part B review itself is hopeless. It has there's no prima facie case made out in the papers in respect of the Part B review, and we deal with this in our heads of argument. I'm not going to read all of it to your ladyship, but if I can find if I'm lucky enough to find my copy, which I've cunningly.
Mr. President, the Part B relief is not before me, or is it before me?
Your ladyship has to be, to grant an interdict, your ladyship needs to be satisfied that there's a prima facie case there. Not that they've got a good case, but that there's a case which can be justified.
And then one have regard to Part B.
Then yes, because
that is the relief that will be claimed at the end of the day.
yes, because if the case is hopeless, then you don't grant an interdict. So paragraph 6 of our heads of argument, I beg your pardon, paragraph 63 of our heads of argument, we make that point about the need for a prima facie right, a prima facie case, I beg your pardon.
Yes, not a right.
Not a right, prima facie case. And then we say that we deal with this in our heads of argument, paragraphs 65 to 74. What the applicant has to demonstrate, prima facie, is that something unlawful is about to happen. Without that, they have nothing. So where's the prima facie evidence that something unlawful
It's about to happen.
is about to happen? We know that the pension is going to be paid sooner or later. Whether this month or next month doesn't really matter. But what is the unlawful thing that is going to happen? The unlawful thing is the payment of the pension. And why is the payment of the pension unlawful? The applicant never answers that. What the applicant says is, we don't know. Yet. When there's a Section 12.6 inquiry, we hope that we will know. But you can't get
Expedition.
You can't get an interdict on that basis. I can't show you that it's unlawful, but I may be able to show you later. Just in case, give me an interdict. That's the case which the applicant makes. There has no evidence, none, zero, zilch, nada, whatever you want to call it, nix, which says, here is proof.
I will not use a word that was used in Parliament.
No. I managed to stop myself just in time. There's nothing to show that the payment will be unlawful. What they say is Advocate Batohi behaved badly at the inquiry. That may give rise to such and such a conclusion, which may give rise to such and such a conclusion, which may give rise to the payment being unlawful. That's the best they can do. Now, the interleading groups, the reason why it will be unlawful is still not explained.
No.
Because you've got to deal with it in terms of the Pensions Fund Act. Pensions Act. You can't just make it unlawful because it was... You can't say because Advocate Batohi was rude, she must now be deprived of her pension. She shouldn't have walked out like that. She should have said, may I please excuse myself? She walked out. She said, I want legal advice. When the panel said to her, you can't do it like that, you have to ask to be excused, she said, I'm sorry, I apologize. That's the basis on which this is, the ladyship is to find that the payment of a pension to her will be unlawful. There's a whole lot of other stuff about propositions put to her in cross-examination, and did she say this or did she say that? Your ladyship isn't going to conduct that inquiry and find, aha, I see that she didn't tell the truth in relation to this. She's explained in her affidavit what she did. She's explained. She was asked about things that happened years ago in relation to documents produced years ago, some of which weren't shown to her in advance. And she was asked something, she said, no, I don't think that happened, or that didn't happen. Aha! You're a liar, it did happen. Here's the letter that you wrote 7 years ago. Or the letter, worse than that, here's the letter that was sent to you 7 years ago, which you should have read. On that basis,
your ladyship sent to your email address. And
yes, so how can you say you didn't see, it didn't happen? You must have read it, you should have read it. One can't imagine how many emails arrive at the office of the NDPP in a week. If she read all her emails and dealt with them all directly, she would do only that. Of course, she passes them on to other people to deal with. If I can give a personal anecdote, I was the head of a government department. I was the Director General for 4 years. If I had read every letter which arrived in the department addressed to me, I would have been a letter reader and nothing else, and I would have had no time to run the department. And so there was somebody in my department whose job was to direct these things, to say that doesn't belong to him, that belongs there in that section of that department. Anyway, so that's the basis.
For the unlawfulness.
Yes, that's the unlawfulness. And all of this, in relation to the establishment of the inquiry, is subject to Plascon-Evans, because it's final relief.
Yes.
And her version has to be accepted. So that's what really all I need to say about that. We make the point, if I can give your ladyship the reference, paragraph 77 to paragraph 84 of our heads of argument, we show that the jurisdictional facts for deducting from a pension don't exist, are not alleged and don't exist.
What also caught my eye is that it appears that the moment to determine what may be deducted is the moment that the employee resign, or not resign, the employee.
Retired.
If one reads 37D, it says at time, it's not resignation, at time of?
Retirement.
Retirement. On the date of retirement, this may be deducted, or
That's
am
right.
I wrong?
That's correct. Correct with respect to that. You had what the Act says, you must pay out the pension, but you look at what's owing at that time.
But at that stage
Yes.
in time.
And what's owing is what's owing in terms of an admission of liability or a judgment of a
order.
court. So there's none of that, and there's no foundation for the deductions being made on the off chance that an inquiry, which can't be held, but on the off chance that an inquiry will find that she behaved very badly, with consequences which we don't know. Your ladyship, with respect, as I said earlier, correctly suggested that, in fact, in any event, deductions are different from withholding the entire pension. But even if you say, deduction, 100% deduction is still a deduction, and a prospect of deduction it's not what they want is not only take off what you pay her, but don't pay her in future. The prospect of reduction is somehow also is permitted, even though it's actually just a refusal to pay. But I don't really need to go to that. So the payment of a pension, which is due in terms of the rules of a pension fund, that comes to the next point I need to make, and it's an important point. The payment of also goes to the question of why the review is hopeless. The Part B review is hopeless. The payment of a pension which is due, in terms of the rules of the pension fund, is not admin action, which is subject to judicial review. It's what is called clerical function. Clerical. It's triggered by an event, and it de facto happens. When I was a student, we were taught to call it a ministerial function,
Sure.
which always struck me as very odd. We thought of ministers as, it came from the English law, but ministerial function is something that a low-level administrator does. But in any event, it was it's not a decision which is subject to review. And Lady, that is dealt with in our heads of argument from paragraphs 89 to 90.4. And can I take your ladyship there, because it is a foundational part of the case, of the applicant's case. We're going to review, but you can't review this. And it's dealt with in our heads, in fact, from page
What do
8.
they want to review? Isn't it the decision of the president? B.
Well, yes. Well, it's also in Part A, because Part A is the interim interdict from paying in the meantime. And we say, but it's an interim interdict because we are going to review in due course the decision to pay under Part B, if the decision is ever made. And so what we say, we deal with it, in fact, from paragraph 87 to 90. And we say, paragraph 89, the consequence of retirement is the triggering of a statutory entitlement arising ex lege in accordance with the governing legislation and the GEPF rules, not the creation of a discretionary benefit. Any decision to pay the pension is not administrative action. We make the point, the submission, paragraph 89.3, that the subject of a review is a decision. And the courts have held, we quoted at paragraph 89.3, the key feature of a decision is that it entails some form of choice or evaluation or discretion. A purely clerical or mechanical power, I see the paper in front of me, I put a stamp on it and the money goes through. That's not administrative action. And that is precisely the case here. As the SCA has said, not every act of an official amounts to administrative action that is reviewable under PAJA or otherwise. So, and in any event, the decision by the pension fund to pay Advocate Batohi's pension is not an exercise of public power, because this is a fund which is established in terms of its rules, and its relationship with the members is a relationship between fund and member. It is not a public power. It's governed by the constitution of the fund. And that has been held in the absolutely analogous situation, paragraph 90.4 of our heads of argument, in the Gems case, a case called Famous Idea Trading. That was the case where Gems, that's the government employees medical aid scheme, made a decision about whether to pay out a benefit. And the Constitutional Court said, well, that's not the exercise of public power. The court said, paragraph 90.4.2, this is the Constitutional Court, that the government, also the court found that the government contributes to GEMS qua employer, and that there is no warrant to subject GEMS to greater scrutiny just because its members are government employees. It's like any other medical aid scheme. This is like any other pension scheme. It's subject to the law, including the Pensions Act. It's a private relationship.
Not a public.
And if that's what the situation in the government medical scheme, it must logically be the same in the government pension scheme. So That's the points to be made in that regard. So the review, the Part B review, with due respect, is absolutely hopeless. There's certainly no prima facie case. Then, my lady, the fourth defect is no reasonable apprehension of harm. I've addressed your ladyship about that this morning. There is lots of other ways of getting the money. Police may not be the most effective. LPC may not be the most effective. But what is effective is issuing a summons. That's all you have to do. It's not so complicated. And so there's no reasonable apprehension of harm because there is a way of getting you can get the money.
Yes.
And that's dealt with in our heads of argument in paragraph 54 to 57. And I made the point this morning that if the applicants disavowing an allegation of dissipation is the end of that argument. If they had said, we know Advocate Pretoria has no money and she'll have to use up all her pension, so the money will be spent, she would have had to answer that. If they had said, we know she will use up her pension for the following reasons, she would have had to answer that. There's no such allegation. They just say, well, it might be. You can't get an order of court on the basis of what it might be. Then, milady, the fifth...
Mr. Freeman's submission was, but because of the nature of this money, then one should accept that there's going to be this dissipation.
Milady...
It's not a test, no.
Who knows? Ms. Batohi may be an independently wealthy woman who has no need to use her pension. She may take up other employment which may generate an income, which means she doesn't need to use her pension. I'm in the fortunate position, having reached this ripe old age, that the pension fund is coming in, and fortunately I'm still just standing, and I can occasionally earn a fee. Who knows whether Ms. Batohi will need it?
And that's the problem.
That's the problem. Then, my lady, then come to the fifth reason why this application is no good is the balance of convenience. We deal with this under paragraph 102 of our heads of argument, 101 to 103. What's the balance? On the one hand, there is a tiny, tiny drawing for a few months from the government employees' pension fund. As against that, there's the impact of an individual deprived of a pension for which she has worked and which she's earned. The balance of convenience just doesn't.
And to which is contributed.
And to which is contributed. And which is a condition of employment. One of the reasons people take up government jobs is that the pension system is quite good.
Yes.
You take it up and then they say, no, you can't have the pension. Well, there's balance of convenience there, which the balance of convenience harm is overwhelming. Then finally, then sixthly, the applicant has an alternative remedy. Can I just refer the court to paragraphs 104 to 106 of our heads of argument? I've dealt with that, in fact, already. You don't have to go to the NPC or wait for a criminal trial. You just issue a summons. That's what the rest of us do when somebody owes us money. And there's no reason why the GEPF can't do it if it ever gets to that. And in fact, that's what they're asking for. In Part B, they're saying, we want to sue you for that.
Yes.
And we want to order on you that you must pay when we sue you. And in Part C, we want a procedure for determining the amount that you owe us. So they acknowledge there's an alternative remedy. Well, then they've got an alternative remedy. What they are seeking in Part B is the alternative remedy, which in Part A they say doesn't exist. Finally, my lady, that brings me, brings me to the question of the underlying fatal flaw. The underlying fatal flaw is the applicant's failure to produce any evidence that shows that either an unlawful act has taken place or that an unlawful act is going to take place. That's the first thing you need for an interdict. Without that, you have nothing. There is no such evidence. There is not even an allegation that an unlawful act is going to take place. All there is an allegation that an act is going to take place which might turn out to be unlawful. That's not a basis for an interdict or for anything else, because it is only unlawful conduct that can be interdicted and reviewed for that matter. And the applicant must prove, or at least demonstrate prima facie, that there has been and will be some illegality. It's not even alleged. What the applicant really wants is this. It wants an interdict to stop the payment of Advocate Batohi's pension, just in case one day it can find some unlawful conduct which permits the withholding of a pension. That's its case. And I invite our learned friend to say that's not the case. Its case is withhold it now in case we find a basis, because we think we might find a basis. Well, they might, and they might not. And one hopes, and they hope they will do it through a Section 18.6 inquiry, which falls flat on its face. Section 12.6 inquiry. I always refer to it as 18.6. 12.6 inquiry, which falls flat on its face. So this is a case, my lady, in summary, which floats in the air. The first half of our learned friend's heads of argument, about 20-25 pages, is all about establishing the proposition that if unlawful conduct takes place, the government should and can take steps to remedy it. We agree. The question is, has unlawful action taken place?
Maybe that's why my debate with Mr. Premin was a bit longer, because I was trying to establish...
Where's the unlawful act?
Pardon?
Where's the unlawful act? Yeah. So, my lady, the case is, it floats in the air. It's untethered to the ground by any facts. One of the astonishing things about the applicant's heads of argument when you read them is how few references there are to facts. It's all about hypothetical, if this, then that. If this were that, then that were that, and somebody would bear a duty. But the facts are lacking. It's a case which is hypothetical, and it is a case which is speculative. And on the basis of that hypothetical and speculative case, the applicant asks your ladyship to prevent Advocate Batohi receiving the pension she earned before she retired as NDPP. And we respectfully submit the court will not make such an order. Finally, my lady, on costs, we all know that the Biowatch principle contains an exception to the general rule.
Yes, yes.
The exception is that if the application is frivolous or vexatious or in any other way inappropriate, then you don't get protection under Biowatch. And we say that this application is fundamentally inappropriate for the following reasons. Firstly, the manner in which it has been conducted is inappropriate. The applicant has waited for 2.5 months after its cause of action arose, and then instituted an urgent application. Now, your ladyship has found that to be heard, and I don't quibble with that.
Yes.
Your ladyship has the discretion to exercise. But what can't be disputed is that it waited for 2.5 months before it instituted the application.
Oh, that's facts.
That's a fact, and that's inappropriate. Secondly, the second thing that is inappropriate is the scattergun approach to the respondents, to citing the respondents and working out what relief should be sought against whom. We still don't know.
But was it that difficult to determine? I mean...
There are statutes, my lady. There are statutes which say this is who does what.
Yeah.
Very simple. They don't say the president pays pensions. So it's not so difficult. The third reason it's inappropriate is because it has brought an application for an interdict when the fundamental element is lacking, namely any allegation that something unlawful is about to happen. That's lacking. Fourthly, it's inappropriate. It's because it's an application which is in truth a fishing expedition. They want an inquiry to be held, and they want to see what comes out in the wash, to mix my metaphors. And they hope something will turn up, as Billy Bunter used to say. They hope something will turn up which will justify the order that they seek. You can't litigate on this basis. I don't want to be filled with doom and gloom, but if your ladyship, if this sort of application be granted, everyone will bring these applications because it's a form of discovery. I'm going to make an application for an interdict and a review about something which hasn't yet happened. I don't know when it's going to happen.
I don't know what the outcome is.
I don't know who's going to decide it, and I don't know what the outcome is going to be. But I'm bringing it anyway because I think something may turn up in the wash. It would be your ladyship and your ladyship's colleagues will be deluged with people who start this new method of discovery and litigation. Fifthly, one has to ask, well, I ask myself, what could be the motive for a political party to bring such a patently baseless case? Why would a political party do this? What would its motive be? Now, I'm not going to speculate, I'd rather stick to the facts. But the fact that such a bizarre, with due respect, bizarre application is brought is reason enough to suspect that there's some other motive which is ulterior to the proper purposes of litigation. There is something else afoot here. And it is an ulterior purpose, whatever it may be, and we could all speculate, not so difficult to speculate, but a purpose which is ulterior to the purpose of litigation, which is to establish the truth, is itself sufficient reason to order that the litigation, to find that the litigation was inappropriate and inappropriately conducted. And so we ask the court to order to dismiss the application and to order the applicant to pay the costs. We submit that the courts need to mark their disapproval of this kind of conduct and also to discourage it so that the courts aren't burdened using valuable and scarce time and energy dealing with something which really should never have seen the inside of a court. It wastes public funds, as one of my colleagues remarked, somewhat ironic. The application is founded on the basis, we must protect public funds. Well, the most profligate waste of public funds has been this application against 11 respondents, not knowing which one is the right one, and hoping that some of them will pitch to court, and the long list of row of counsel that your ladyship sees before her. That's the waste of public funds, not paying Advocate Batohi her monthly pension. So we submitted under the circumstances, the court ought to order that the applicant is to pay pay the costs. We ask for the costs of 2 counsel on scale C.
Well, if it's attorney, are you requesting attorney-client or not?
Can I take an instruction there?
Yes, I just thought you were going.
I need an instruction. Yes, lady, we ask also for attorney and client costs because, in truth, this application is an abuse of the process of court.
Otherwise, 2 counsel, scale C.
Otherwise 2 counsel on scale C.
Thank you.
As the court pleases.
Mr. Bailey, it is almost 10 past 4. Can we take a 5-minute break?
That will be in order, my lady.
And how long do you think you need?
Less than 10 minutes, or rather 10 minutes.
Okay.
Not less.
Thank you. Mr. Premin, how long would you need to reply?
No longer than half an hour.
Okay, the court is going to adjourn for about till 4:15.
Thank you for your help. It's going to do something very important. Do that. Did this for the reason I said, which is what happened. Just well, it's like
Yeah.
Okay, this is our first time to send it. Okay, hold on. Why are you sending me papers? I can't sit down.
Well, she must be is she grown since which is true. I don't want to say anything because I would have told you if she was obviously going to start it.
I came to the phone from now because I was like, anything can happen.
Well, that's the truth.
You know, I was acting in blue now. I need to do it. That's where your hands are.
Hey, yes.
So I love it. I don't like it when people go, all this time, please.
Yes. He's very practical.
Yes. I was hearing it. It's
very hard to come up with.
All right.
Yes, Mr. Wetty.
Of the exchanges between the court and counsel for the applicant earlier about the role of the minister now, whether paragraph 2 or prayer 2.1 and 2.2 are still going to be pursued against the minister. I took it from my learned junior because I was still engrossed in my reading that I understood that the submission was that the order will no longer be sought against the minister.
Yes, you're quite right.
Yes, my lady.
It's against the 10th and 11th and the first respondent.
Yes. Our submission is that it makes no difference in the sense that the minister is here.
Yes.
This morning, submissions were made to your leadership about an offer that was made to the minister to release the minister and the DG on the same basis as the NPA. As I rose this morning, was no fixed offer, had the applicant intended for the minister or to carry on, the submission to the court was that there was no response to the letter. A response exists somewhere. I don't have instructions as to what happened to the letter that we drafted. That does not matter. What we're saying is that if that was still the intention, this morning the first submission would have been, we have not been responded to. However, we no longer proceeding against the minister.
Yes.
The minister makes full submissions. The defense is raised. We submit that they should stand, even in favor of the 10th and the 11th respondent. And then that takes me to the next point. If there's any doubt, it takes us to the next point. If there's any doubt of the entitlement, or rather, of the second respondent to the pension payment, that is in terms of section 12(1) of the NPA, the submissions have already been made. During the submissions made by Counsel for the President, they referred to Corruption Watch, which we have now uploaded in case lines in section 8, part 7.
Section 8, part 7, thank you.
The Nasana case. And the reason why I want to refer to this particular section in the judgment.
Just a moment, let me just get this.
Yes, it appears in section 8, part 7, page 008139. That's this part of the judgment that we'd like to refer to.
It's 007 hyphen
8 hyphen 139.
It's 008
008, my lady. I beg your pardon.
hyphen 139, thank you.
139, yes. Paragraph 28 of that judgment. That this judgment related to an amount of money that was offered to Advocate Mwasana in exchange for vacating office, which the Constitutional Court struck down as unlawful. And this is then what the court said, the remarks that it passed about the entitlement of the NDPP of pension benefits. Towards the last line, just after the footnote 27, it says, when an NDPP vacates office for any other reason which the President deems sufficient, he or she shall be deemed to have been retired in terms of section 16(4) of the Public Service Act, and he or she shall be entitled to such pension as he or she should have been entitled to under the pension law applicable to him or her had she retired ordinarily. In the case of Advocate Batohi, is in terms of section 12(1).
Yes.
On the occasion of her turning 65.
Yes.
So that tells the court that the second respondent is entitled to a pension as a matter of law. As a matter of law. And because she retired without any finding, and those submissions were made earlier on, I will not repeat those submissions. There is no misconduct that would, well, even if there's a full inquiry, even if by some chance prayer 3 is granted, and there's an outcome that says she looked at people sideways, so didn't there's that found her wanting as a professional, as your ladyship pointedly asked, what then? How would that then affect anything about what we're fighting about in prayer 2, in the withholding of pension?
Yes.
And I will not take it further than that. And my lady, the second point, which is my penultimate point, is prayer 3. This matter turns on prayer 3, on whether or not this court can in fact have the power to order the president, or rather the president has the power to be ordered to exercise as contemplated in prayer 3. My learned colleague for the president has already made those submissions. We've already also made those for the minister, as well as on behalf of the second respondent. That power doesn't exist. If prayer 3 collapses, the entire application collapses. It must be dismissed. And there is, in the notice of motion, part B, paragraph that deals with a purported review of a decision to pay the pension payouts. On my earlier submission, or the pension benefit, on my earlier submission referring to Masana, that can never be. But secondly, my lady, when someone reviews a decision, that decision has to have already been taken. in order to engage the jurisdiction of this court. Otherwise, that particular portion of Part B is inchoate. And the court cannot grant anything pending something that does not exist because it does not have the jurisdiction to do so. There's a recent case in the Constitutional Court, famous ideas, that says, in order for the court to engage itself with what you're complaining about, you've got to engage the jurisdiction of the court. The reason why we raise it is that Part B calls upon the respondents, that those whose decision seeks to be impugned, to produce the record. What record is going to be produced in the circumstances of the notice of motion as it reads now? We submit, my lady, therefore, that Player 3 collapses the entire notice of motion, or rather application, must fail. I will not make any submissions on the entitlement to interdict. We deal with it from paragraph 32 of our heads. We rely on each and every one of the submissions we made. My lady, finally we submit this application must fail. It was so unmeritorious that to even mention that it was in the public interest, that it's not a reasonable submission to make. We submit that BioWatch is not applicable to the circumstances of this case. Insofar as the minister is concerned, on the applicant's submission or concession in their own replying affidavit, the minister was not supposed to be dragged here. So whichever outcome that they have, or this judgment is going to have, the minister's costs have to be paid by the applicant on scale C.
To counsel.
That would also be a
That would be a thumbs up.
Yes,
Thank you, Advocate Tabini.
Madam, I just asked for an indulgence, please. I had, when I was on my feet, I made a note that I wanted to say something that had escaped my mind.
Yeah.
What I had wanted to say was that the president doesn't have the power, but that power is explicitly given to the LPC in section 37.
Well, that's a body that was established, statutory established by Parliament to look into the conduct
Of lawyers.
Yes.
And
Professional, fit and proper, that's all there.
Investigating committee consisting of a person appointed by the council to conduct investigation of all complaints of misconduct against legal practitioners and candidate legal practitioners. That's all, and I'm indebted to your ladyship. Thank you.
Ms. Premin, you say 30 minutes, and I'm going to keep you to that.
I hope to be quicker.
Oh, fantastic.
It's not often you'll hear me say that, but on this occasion, I'll peg my colours to the mast. My lady, can I start with my learned friend, Ms. Chabedi, if I may?
Yes.
Just three very brief submissions in reply. The first one is that the minister, after having received the letters, kept quiet, then filed this full answering affidavit that not only spoke about the minister's role, it also spoke about the NPA's role. Now the Minister's Council on her feet was addressing you as to why the minister's arguments can also apply vis-a-vis 10 and 11. So to the extent the minister is still in the proceedings and wasn't cut out sooner, that's because the minister chose to take it upon themselves to swing the cudgel, and my client was entitled to swing back. So to the extent there's a criticism now leveled that no attempt was made to cut them out sooner, that's the explanation. That's point number one. Point number two, my lady, you heard me in opening about why the Mpasana judgment is distinguishable. It's distinguishable because my learned friend summarized it correctly. It was using a 10 million rand payment as a means to cause a vacation of office that was otherwise not provided for in law.
Yes.
And that, then once the person is lawfully vacated, they are deemed to be pensionable in the way that it would ordinarily apply. My lady, no matter how much the respondents and the minister tries to argue that that's the world we're in, the very relief in front of you is about something entirely different. And so, in fact, it's not competent, it's not sufficient, I would say, with due respect, for our learned friends to just push back and say, oh, well, 12.1 and 12.6 or whatever. We're asking you to address, at least at this stage by means of your interdict powers, the very gap that all of our learned friends rely upon with the end consequence that no accountability will occur. So, my lady, I can accept the Nkosana judgment to the extent that it says what it says, and my learned friend quoted it, but it doesn't take the debate any further insofar as what you, your ladyship, is being asked to do here. On the last point, with respect to our learned friend cited the famous ideas judgment and said that, in order for you to give any order, your jurisdiction has to be triggered.
Yes.
I mean, that's an obvious proposition. I wholeheartedly endorse that and accept that. The point made, however, is that the Part B debate, which is about does the power exist, is what will determine whether the jurisdiction exists here in Part A for you to grant an interdict or not grant
Now, I
an
must
interdict.
decide in Part A whether the power exists.
No.
You are asking for final interdict.
Sorry, my
It's
lady,
not-
I spoke before I should have. I apologize. I'm sorry, my lady, please go ahead.
The relief in Press 3 is
As against
not,
the president.
is not an interim interdict.
Yes, no, I accept that. I accept that. Which is why I apologize for speaking too soon. I should have let your ladyship finish. I apologize for that.
And then it's a clear right and so
Yes.
forth.
And what your ladyship will know is there's a judgment in Eskom versus Vaal Residents Association, paragraph 70, Justice Unterhalter, relying on KZN Gambling Board and earlier decisions, is that a court hearing an interim matter, if the facta probanda exists and the lawful entitlement exists, grant final relief.
Yes, yes.
So on the
No, it is just that we have been, in our interaction,
yes,
we've referred to a prima facie.
yes.
And the heading is interim, urgent interim interdict. But
Yes.
be that as it may, yes.
Yes. Well, you have my submission then that you are suitably positioned to consider the final relief question and grant the final relief if you think the case has been made out. That's
Well,
really.
I need to find that there are powers
Yes.
on a final relief basis.
Yes. And can I talk against myself very briefly to say this? If you're not minded to find here in final relief in the urgent court that there is no such power, rather than going the full way that our learned friends have invited you to do so, which is to dismiss it. My learned friend, Mr. Budlander in particular, went quite far in saying that it's a hopeless case. And you know from Pioneer Foods what the definition of a hopeless case is.
Yes,
The danger that I would submit to your ladyship is that would have the preemptive effect of shutting the door on the applicant on a contested...
I did not persist to hear the matter in the urgent court. Neither did I draft the notice. It is before me as it is.
Yes,
And I need, in the interest of everyone in this
Yes.
court, I need to adjudicate what is in front of me.
yes, and
So what is your suggestion? If I
my
find
submission is that in doing the very exercise that your ladyship has foreshadowed, which is the exact exercise I'm saying that your ladyship will do,
Yes.
I would just say that you know, for example, the relationship between a Part A and a Part B judgment. And you know, for example, in the Inflameza case, Justice Tupton, whom we spoke about earlier, was criticized severely by the Supreme Court of Appeal for going too far into the merits of Part B and making
I do
determined...
not need to do that. You are asking this court in Press 3 to finally rule on the powers of the President. I don't need to go to Part B. That is what you asked this court.
Yes, my lady. All I was submitting, and I wasn't saying anything otherwise, all I was submitting is I'm asking your ladyship to exercise a degree of caution that whatever finding you make in Part A doesn't have or necessarily have an effect, that it shuts the door in Part B.
I can only do what the law allows me to do.
100%.
Whether there's doors that's going to be shut, I cannot not act as a judge because doors may be slammed closed. There are facts before me, there's law to apply, and that is exactly what I'm going to do.
Exactly.
Whatever the consequences.
But insofar as those consequences are concerned, I'm entitled to advance a submission in front of you to say, my lady, that the terms of your judgment, however that judgment ultimately comes out, should please carefully consider what the effect may be, the negative effect may be. Your ladyship may say that's the consequence of the litigation. That's
I
the
really do not
consequence of relief.
understand where you're going with this. You may proceed.
I will make progress, my lady. So you've heard me on that. Insofar as my learned friend Ms. Muvangwa, when your ladyship is analysing the arguments made about the founding affidavit and the pleadings, would your ladyship also look at 001-50 to
001
-50 to 001-52, paragraphs 167 to 185, and paragraph 185 in particular?
Thank you.
On the heads of argument, will your ladyship please look at 005-31 to
Just a moment. 005
-31 to 005-32, and your ladyship will look at paragraphs 137 to 143.
Thank
there.
you. And this is in respect of the case that's made out.
Yes, and this, this 12-6 clarification, which was said to have only happened
Yes.
today.
Now I have you.
Thank you, my lady. I appreciate it. I'll deal with costs under Mr. Budlander. I'm not going to deal with costs under my learned friend. I'm just looking through what else my learned friend said. Oh, yes. Can I just make 4 very brief points on the authorities that she cited?
Yes.
The first one was Motao. My learned friend is very modest. She doesn't say that she was the successful junior counsel in that case, if I'm not mistaken, on behalf of the minister. And it's a case which I've read very carefully for very many years thereafter. But the paragraph 70 that my learned friend refers you to is the exact paragraph that I rely on, because the dispute in Motao was whether or not the minister, to exercise a power to remove a director from the Arms Corps board, was exercising a power either under the Companies Act, Section 71 type of removal, or whether they were exercising an administrative action power, and that's the debate in which the legality principle arose. The only point I would make about that is that the court was willing to accept that regardless of the source of the power, that provided the rational legality connection existed, that the minister's decision then to dismiss those particular directors met the threshold of rationality. And so we say that this attempt to disaggregate the source of the power asks the wrong question, because Motao tells you the answer that we have one unitary system of law which is regulated under the Constitution, and that's where legality and rationality comes into the debate under public powers. So that's Motao. The second response is on the Masetla judgment. And all I would say about Masetla, because we debated it earlier and your ladyship took the point about implied powers, is look at the objective that the court had regard to in Masetla. And the reason I mention that is because all my learned friends contend that the 12-6 power is the removal, and the consequence is the removal.
Yes.
But what your ladyship heard me argue earlier is that the 12-6, at least as against the president, is to do the fact-finding mission and the fact-finding inquiry. And so in asking for the equivalent under that, that we're asking for nothing too distinctly dissimilar, even though the consequences, removal versus no pension, may themselves be different. So we say that Masetla is authority for us. Can I say that on the Pikoli judgment, I heard what my learned friend said. I think, if I'm not mistaken, it was the 1999 Pikoli judgment that my learned friend relied upon. I'll just make 2 very brief points. One, Masetla came after that. So this question about implied powers and how strictly they have to be expressed or not expressed is not, as my learned friend suggested to you, as readily resoluble under Pikoli as she otherwise suggested. And the other one is that the growing body of jurisprudence, the Ramaphosa judgment I spoke to earlier, cabinet reshuffle, that one was about inventing a precautionary suspension power where it didn't even exist at all. And the options for the president is either dismissal or appointment. And so in that continuum between the hard power of either appoint and the hard power of dismiss, the court was willing to say that there is something that exists within that continuum, provided it is exercised in a way in relation to the express power.
That makes sense, because between
Yes.
appoint and dismiss, you may
Yes.
put someone.
Correct.
That makes sense,
and-
because that will fit into the middle of those
Yeah.
two.
I mean, I think where your ladyship and I might disagree is that I say that logic applies to how I interpret 12.6, and your ladyship might take a different view on that. But you've heard me already, I'm not going to spend more time on that. And there was a passing reference to the Western Cape versus Premier Western Cape judgment. We say that that equally applies to us here. My lady, Mr. Budlander then last. May I just
But
say...
not least.
Certainly not least, especially now that you can see him, I suppose. But that said, my lady, I want to start with some of the submissions that Mr. Budlander made at the end, because that is an interesting prism through which he imposed the way in which your ladyship has to evaluate this litigation. And what my learned friend Mr. Budlander did is he went into the merits of the defenses that Ms. Batohi may mount at any given time when called upon to do so. And the criticism which follows in respect of those allegations is that we needed to adduce a stronger evidential case to demonstrate the existence of the misconduct. 2 points in response to that. The first one is that that's not your role. That's not what the court is being asked to do. So that overly onerous burden about showing the evidence of the misconduct is perhaps overstating the burden we bear. But to the extent that my learned friend makes the correct point in the relationship of the prima facie existence of the case, we'd say we meet the threshold. And the way in which the court, your ladyship will know this, the way in which the court recognizes the establishment of these things in the context of an interdict is that the stronger and more clear your claim is, then the more likely the court will grant. But just because the claim is open to some doubt, even very strong doubt, doesn't mean that the court will disregard. The court then reverts to the other requirements like balance of convenience, alternative remedies, and irreparable harm in order to make the interdict decision. If my learned friend was correct about the standard that had to be met in interdict disputes, we would never, no party would ever get an interdict because of the strength of evidence required.
Differentiate between the interim relief and the final.
Yes, I accept that. But I say that we've met it in respect of both. So that's one thing. And also, my lady, the extent to which the evidence or lack of evidence or defenses against Ms. Batohi is not engaged in front of your ladyship is also because that's the very thing that a Part A court, Justice Tugton in the Nkabinde matter, got reprimanded by and overturned by the SCA on when he reached into Part B and started making those kinds of merits-based evaluations, potentially finally even, to make a determination in Part A. And I would say that those are the subject matter properly going to be debated in the review. What you have to ask yourself, my lady, sitting here, is has a prima facie case that centers on alleged misconduct been made sufficiently to trigger...
Not prima facie, a final case.
Final. Whether or not a sufficient case regarding alleged misconduct has been made for the president's obligation to be triggered. That's the true question. Not whether the defenses are good or the defenses are bad and all those kinds of things. It's about the president's obligation. So once, my lady, with all due respect, you understand that those impositions, understandable as they may be from a respondent, are actually not the correct impositions, it then takes us to this 12.6 point about, if it's not good, then it all falls down, and if it doesn't, then we continue. Can I say, my lady, and at least from my engagement with you in the morning, I think I made that pretty clear myself. And to the extent it's not clear, I think Mr. Budlander is correct.
Yes.
Obviously, if the 12.6 thing issue power is not there, then the case will fall. That's not contentious. What is contentious is whether or not, in the circumstances that we're talking about, that the NDPP is a former NDPP is accused of serious misconduct in a tribunal inquiry, whether or not the president is effectively, through this response, says, I'm entitled to turn a blind eye towards this.
We will not know because there is no, at this stage, there are no facts before me of serious misconduct.
But that takes me to the point that they can't, well, beyond what is contained in the papers.
You want this court to tell the president to set up inquiry. Otherwise, the president will turn a blind eye. It's in that sense that I say, if there were allegations, enough, I'll read the papers again. It's a final interdict. If there was sufficient, and I'm satisfied on the on the applicable Plascon-Evans rule,
Yep.
that has been established,
Yep.
then I will.
Yep.
But it is not necessary to say that then the president turns a blind eye.
I accept that.
Yes.
May I continue, my lady?
Yes, please.
Thank you. I just want to do an audit of my notes.
100%.
My lady, I've just asked my junior, Ms. Makwingwane, to call up the Corruption Watch judgment, which several parties have made reference
And
to.
it's now been uploaded, yes.
Now been uploaded. I don't know if I'm reading from the. I think I'm reading from the unuploaded version. I would say, my lady, I'm sorry, I'm looking at the unuploaded version. I'll try and find the
No,
page
you may
reference
just
for you.
refer me to the paragraph. That's been,
87.
paragraph 87.
Yep, 87.
Yes.
And 88. To the extent that we're talking about the president's obligation and inquiries, and again, I readily accept that those were for current NDPPs, but you've heard me about the extension. Thank you, my lady. Obviously, my learned friend, Mr. Budlander, said various things about the case being speculative and hypothetical, and
Fishing expedition.
I'll come to that separately because that was one of the things he said about costs. I'm adopting the first two things for a different point, speculative and hypothetical, and whatever the case is. Of course, my lady, because as the applicant comes to you today in court, it's in the foothills of a process that is going to result in a finding at some stage that will have consequences, if your ladyship is with me, for the former NDPP and her willingness, or ability rather, not willingness, to claim the pension. So to the extent that the criticism is made that it's not done with sufficient precision, or all those kinds of criticisms, your ladyship knows from Bartow Star and the Constitutional Court, even when you identify the type of review you're bringing, the Con Court doesn't expect you to say it's 6.2 sub 1 or whatever the case might be.
Well, there's nothing to review at this stage.
Yeah, well, that's a different point to the one that I'm making. I'm just simply saying that for the litigation with where it is, it's understandable that the case is framed in the way that it is, and that's obviously subject to the ordinary refinement procedures that comes with respect to the Part B. Obviously, my lady, in respect of the statement that there's nothing to review at this stage, we are confronted with the difficulty that what is the target of the review has only been clarified as the matter has moved. You heard me earlier about the letters of demand and the position being set out in the answering affidavit. I hear the criticism made by my learned friends, well, you could have just looked at the act and you could have deciphered it for yourself. That may be so, my lady, but you know that and this was the Odekral point I made earlier about at least in the initiation of litigation, a litigant can hardly be criticized for reasonably citing the parties they think have something to do with it, the decision in question. And in particular, for example, in the minister's affidavit.
Well, let's not go there. Yes? Yes, you may proceed.
Thank you, my lady.
Now, you said the decision in question, so there isn't any decision, but you may proceed.
No, what I was saying, with all due respect, is that it's not unreasonable for the applicant to have cited in the way that it did. Mm-hmm. And to the extent that there is any issue about decisions or whatever, can I just disaggregate it as follows? With respect to the pension, obviously we know what the position is now with the 10th and 11th. My learned friend's response on that, if I understood him correctly, is that these are minor clerical issues and that clerical issues are not subject to review. That's the thrust of the argument if it's a clerical issue. I would say, my lady, that the Supreme Court of Appeal in Rhino Oil said that that's not actually the case. The Supreme Court of Appeal in Rhino Oil said that a clerical error may become the subject of a review where the clerical error has a material connection to the prejudice claimed.
Clerical error or clerical decision?
Clerical error made, or clerical decision error, whatever the case might be. I'm talking about this bundle of decisions that are taken by, or let me not use the word decisions, these bundle of things that are done by public functionaries that don't constitute administrative decisions. They're more of a clerical nature. And what I'm saying is that the Supreme Court of Appeal has accepted the principle that where those clerical errors give rise to prejudice, that may be actionable for the purposes of a review. Because understandably, the consequence, if it were not subject to review, is that you live with an adverse outcome that is premised on an error or an unlawfulness or whatever the case might be, and you never have the right to approach a court to undo it.
And once again, that principle must be applied to the facts in this matter.
Yes, I accept that. So that's the issue. That's the issue of clerical errors. Obviously, if it's not, sorry, the citation for Rhino Oil, square bracket 2019, Zaska 88, and we say that you will see that test at paras 30 to 31.
Thank you.
Obviously, if it's not a clerical decision and there is the application of the mind, even in the slightest respect, then that would be admin action, and that would open the door to the review. I understand what our learned friends say, it's just stamping a form or whatever the case might be, but we say that it's not so narrow, that in fact, when you have to consider, can I put the stamp on the form where there are countervailing considerations, in this case, misconduct and the like, that you can't simply just stamp the form, you have to apply your mind as to whether or not you can. Because we also know that in different scenarios, repositories of power not only have obligations triggered by the other, they also have mero motu obligations. And we know that that's particularly relevant in the context of constitutional office bearers and the like. So you've heard me on that, both on admin action and clerical errors, to the extent it applies. You've also heard me on why outer is the incorrect comparison. My learned friend pushed very hard at outer. You've heard me as to why that's not the case. Obviously, he's correct, or he would be correct potentially, in the 12-6 President Inquiry, but not in respect of the pension payout inquiry. But as I said,
we all agree that the President Inquiry, this whole case pivots on that.
Yep.
So he's correct in the OTA approach in respect of the relief claimed in Press 3.
That it would need to meet the higher outer threshold, which we say we meet. It doesn't apply as respect the pension payout decisions, which is the lower threshold precision motors. Your ladyship has the submission. My lady, lastly, on costs, in the first instance, I'm not sure all the speculation about motive and whatever else the case has any role to play in these proceedings. I also don't think those were on the papers, but to the extent they are, my learned friend said what he said, all I would say is, of course, your ladyship has a wide discretion on costs. You'll take into consideration the case made, and you'll take into consideration what my learned friend said. I just simply respond by saying there's absolutely zero foundation for that. Certainly not one laid out in the papers. So make of that what you will. And your ladyship knows, at least from as far back as one of those older DA cases where they were attempting to review and set aside a prosecutorial decision, the Constitutional Court emphasized that even political parties are known to act in the public interest on occasion, even when they approach a court. And we say we're directly in that territory. I don't know if I've been longer than 30 minutes, but may I take an instruction? Thank you. My lady, thank you very much. We're indebted, obviously, to you and to the court staff, particularly for sitting after hours as well and for making yourselves available. Thank you.
Thank you. Thank you to all counsel for the addresses. It was most interesting, and for your heads of argument that will afterwards help a lot. I am going to reserve judgment. The parties will be informed when judgment will be delivered.
My lady.
Mr. Freeman.
Yes, I was just going to say that I'm so sorry. Because of what I said earlier to you in opening about that 60-day cutoff, that cutoff is obviously coming next week.
Yes.
So we might be in a position where...
Now, what I have in mind, and I've thought about this because it's one thing to do reading and form a view. It's another thing to put that on paper.
Yep.
So it might be that the parties will be, that the order will be given and
with
reasons to follow.
Yes, that was going to be my request, my lady. I'm indebted. Thank you.
Okay, court will adjourn.
You're going to come to my house, right, Inga? So,
5 is gone.
no. I was going to say, let's take it home, but let's maybe put it in your car.